Cheers.
All right.
Okay, we'll hold the meeting to order. Are commissioners online able to hear us? Good.
Yes, good morning.
Good morning. So the first item is adoption of agenda and consent agenda. Was there a change to that or not in terms of the agenda?
The agenda only that I added the quarterly reports to it.
Yeah,
Since perhaps
okay.
the first time you saw it. If you have a copy of the agenda that's in the room, that is correct.
So we hear a motion to regards to the agenda? Second.
Moved and seconded. Any discussion? Seeing none, the commission's remote participation policy requires that commissioners indicate their vote both visually and audibly. So when I call your name, please say your vote and raise your hand. If you vote yes, you are in agreement with the motion. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Sorry, yes.
No.
Yes.
Commissioner Sanders?
Yes.
And director's report.
Minutes.
Oh, minutes, I'm sorry.
That's
Yes.
right. I have a motion to adopt April 2025 minutes.
So moved. Second.
Moved and seconded. Any discussion on the minutes? Okay, seeing none. If you vote yes, you are in favor of the motion. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay.
And then our agenda for hearing.
You want the director's report?
Yeah, it's listed. April 25 commission meeting, I mean.
Oh, I should say minutes after that.
Oh, I
should say
see.
Minutes.
Yeah.
Sorry. Probably deleted that when I was editing it.
All right. Director's report.
Okay, so for administration personnel, we have no change in personnel. Fingers crossed. Compliance, you have a memo from Jane as to the status of conciliation cases. We have 4 active conciliations, 2 that were unsuccessful and 1 that was successful. And for that one, I have an agreement to approve in PA 23-0240, Heffernan versus Sabatis disc golf. I have a motion to approve that agreement and allow me to sign on your behalf. Thank you, Commissioner O'Brien.
Second.
Moved and seconded. Any discussion on that agreement?
Oh, seems correct.
Great. Seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Walker? Sorry.
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Told you it's gonna be a big coffee day. For new charges, we had 43 new complaints filed with a total of 57 respondents.
Is that this report?
That is that report, yes. 28 administrative dismissal letters, 11 right to sue requests, 2 withdrawals with no benefits. And then for predetermination settlements, we had 9, 6 through the commission's mediation process and 3 private settlements for a total of about $264,000 to complainants. If you're wondering why there are so many more ADs and closures for this month than there were last month, it's because this month was me catching up after all of the time I spent at the legislature last month. So probably the same thing you may see in June, because I have been at the legislature and will continue to be there for a lot of May. For the quarterly reports, you have a new format for the pending inventory report. We are trying to be more reliant on our own internal database as opposed to the EEOC's database, because we are moving away from tracking every single case in that database and moving to only file cases that are actually dual filed with the EEOC only in that database. So this is a new format that I'm trying out, that sort of gives you the same information that was in the EEOC sort of screenshot of the PDF that I was giving you before. If there is other information that you would like to see in this report, please let me know. This is mostly just sort of the average case age in terms of days, number of days since it was assigned to an investigator, and then for cases that are still in review, the number of days for that.
But the average days
Yeah.
since assignment doesn't tell us what the average is for completion, right?
No, that's just how long cases are waiting before they get assigned to an investigator. If you would like to know sort of the average age at closure, I can add that to the next report.
But what always comes to mind when I look at this is, okay, how we doing? You know, what's the quality, what's the qualitative adjective that goes with the, you know?
So, sorry, can I see that? I didn't print one out for myself. Yes, so their cases are waiting an average of about a little less than 6 months before they are assigned or invited to participate in mediation, which is that's sort of what we aim for, is to get those to review by me within 6 months of the complaint being filed. So we're doing fine on that. And then the average days that that's not what I gave you is how long they have been with an investigator since they were assigned. So that's sort of like how long.
The investigation takes.
Yeah, roughly. About 6 months.
But case age, what does that specifically mean?
So that is how long a complaint has been here total. So since the day it was filed until the day that I ran this report.
Right.
So we're doing pretty well. About 750 pending cases with an average case age of a little less than a year. Not bad. But if you think of anything else that you'd like to see in that quarterly report, just let me know. It's pretty easy for me to pull that information out. I have a handle on how to get reports.
I guess the only question would be if the report could be expanded to show the last one before it. I mean, what's the trend?
Yeah, and
Where's
I
it
think
going?
going forward, we'll be able to do that more easily.
Yeah.
Our database doesn't talk to the EEOC's database, so it's hard to sort of pull that. Because I could run the same report but with different parameters for the date.
Right.
Give you, so maybe for the next quarterly meeting, I can give you like a year's worth so you can see how that changes.
Yeah.
Is that something you'd be interested in?
Yeah, I think so. I think that would be something that we could understand.
Yeah.
I mean, eventually it affects, you know, budget requests and maybe you need more staff or whatever.
Wouldn't that be nice?
Wouldn't that be?
It will, I hope, make it easier when it comes to writing our annual report, because I'll be able to just pull the numbers from these reports instead of doing what I usually do, which is creating 8,000 Excel reports and then sit out from there. You have a memo on outreach and training. There has been less than there usually is. A lot of so EEOC and HUD often run sort of a monthly training on some topic, and they are currently not doing that. So we have been attending fewer trainings just because there have been fewer trainings. But I and two of our investigators are going to a fair housing conference in Springfield after the meeting today. Report back on that next time.
Is that the result of budget cuts that were unexpected? Or don't we?
At the federal level, I'm not sure how much of it is budget cuts and how much is a priority shift. I do know that a lot of HUD in particular has had quite a significant number of layoffs.
Right.
So there's just less staff to run those.
To run the trainings?
Yeah. And there's usually some sort of like annual conference somewhere, and that is not happening for the EEOC this year. Well, we're just all watching. The conference this week is put on by Western New England Law School. So that's a sort of a private thing. You have a finance report on file. If you have questions about that, please ask Michael.
How we doing, Michael?
We're looking really good this year. We're on track.
We are still waiting. The Appropriations Committee is racing through but I will just say that the legislature generally, and I'll sort of move us into new business, but also related to finance. The legislature is racing through stuff now.
Yeah.
Judiciary's schedule for this week is just full days. And I think they will be there into the evening on a lot of those days. I was at the State House on the 8th for the hearings on a lot of bills that impact the gender identity provisions of the Human Rights Act. I got there at 7 a.m. and I was there until midnight. And I left before the committee wrapped up. So everybody's having big days. They're trying to get through as much as they can. A lot of stuff is getting tabled now until next session. And the Appropriations Committee is running through the budget. As far as I have been able to tell, they have not gotten to our budget. They have done some things in judiciary, but right now they're just doing all of the sort of easy stuff that everybody can agree on and just get it out of the way so that that can go into the budget.
Does judiciary get it back at our budget?
Yes, so we presented our budget to judiciary. Judiciary voted, the only thing beyond sort of like operational, we're not making many changes to the budget. The only thing that we requested new was, I think I explained this to you, about a $25,000 shortfall because we didn't have a director of operations for a while and a lot of things we didn't have access to, so we didn't know that those bills were getting paid. It's not unusual for an agency to carry a balance like that year to year, but we are, in the name of sound fiscal management, attempting to get caught up. So judiciary does what's called a report back to the Appropriations Committee. And in their report back, and that's for all of the sort of budgetary things that they have oversight over. So that's not just us, it's the AG's office, it's the judiciary, like the judicial branch. They have, I forget what all they have jurisdiction over, but it's a big report. It's about 800 pages. And ours is like 3 lines, but they did vote to adopt all of those and they sent that to appropriations. And now we're just waiting. Whenever I get an email saying that appropriations is going to be hearing stuff from judiciary, I try to tune in and listen and see if it's ours. So we're just waiting to see. You have copies of all of the testimony that I have given since our last meeting. The big one obviously was the gender identity stuff, but there are also a couple of other things. If you have questions about any of that.
Well, what is this? What is the status of them now?
So the work session on all of those bills is tomorrow afternoon.
It's tomorrow afternoon.
It's tomorrow afternoon. I will be attending by Zoom from some hotel room in Springfield. Barbara and Colin will be there, or at least Barbara will be there in person. We'll see what happens with those. I don't expect there is a sort of a bunch of different groups. There are a couple of bills about trans girls playing sports. There's a bill that would require that schools only use the full legal name on a child's birth certificate unless they have written consent from their parents to call Robert Bob. There is a bill that would repeal all of the gender affirming care bills that got passed last year.
I saw that in the family law section to revoke
Yeah.
the minor's ability to, or what does it say? The bill said the doctors have the ability to provide the care.
Yeah, so the laws that got passed last year would allow, I think, 16 and 17-year-olds to access
Right.
gender affirming care without parental consent, which they are able to do for certain other kinds of care already. And this bill just repeals all of that stuff, all of the stuff that got passed last year. So it seems unlikely that that one will go anywhere. There's a bill that would remove gender identity as a protected class entirely from the Human Rights Act. I don't want to, I'm not a betting person. I don't think that one will get out of committee.
And is that 1432?
That is 1432, yeah. And then there are a couple of bills about.
So the
sort of-
question is how it comes out of committee after the work session tomorrow.
Yes, yeah, and the ones that I think are, the ones that a lot of people are sort of unsure about how they're gonna go are the ones that reports. Maybe what happens tomorrow, those don't directly impact the Human Rights Act in the way that 1432 and also 1337 like directly try to amend the Human Rights Act, but they would obviously, there would be a big confusion if the sports bills were to pass because we explicitly say in the Human Rights Act that you can't discriminate in athletic programs on the basis of gender identity.
Mhm.
So that would be a problem. That's where we are with the legislative stuff. Any questions about any of those reports or any of the legislative stuff?
Well, I did read it. I mean, I'm glad you give it to us. It is the case that the testimony is being submitted in our name. That's the question.
Yes, and I think at least the Judiciary Committee understands, because they have jurisdiction over it, they understand sort of the role here, and they know that
Okay.
when I give testimony, or when one of us gives testimony, they are asking me questions about sort of the administrator of the commission. I don't know that many of them are sort of imputing the testimony to, all of the testimony says that I have CC'd you on it,
Right.
but not that you like have reviewed it and.
That's right. We don't vote. We don't
Right.
vote on it.
But then we would have 18 public meetings and you all would never get anything else
Yeah.
done.
We do it all.
Yeah.
Yeah.
Yeah, I think so much of it comes up
That's
at the last minute.
That's
Right,
The
that's
way-
the other
Anyway.
thing. I forget one of them. There is a bill that I literally found out about Friday afternoon and testified about Monday morning at 9. So even if it was the way that we did things, you will have to be having public meetings at like 6 p.m. on a Friday, and nobody wants to do that. We don't pay you enough for that.
Yeah, what you pay? What's that?
I don't remember the original.
Shall we
Okay,
move to the hearing?
I think we shall. We're past time. So we'll proceed to the hearings agenda. Before we call the first case, you have preliminary instructions, Kim? Or do you?
I do, the confidentiality provisions, yes. So the commission's confidentiality provisions, both statutory and per our procedural rule, require that we keep the names of third parties confidential. So essentially what that means is please do not reference the name of anybody who's not a named party or any entity that is not a named party. Usually we have given them pseudonyms in the report, so we'd ask that you use those pseudonyms or just make up a title or something like that if you need to reference somebody who's not in the report.
Well, good morning. I welcome you on behalf of my fellow commissioners to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, paper, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda available at the back of the room. Consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases that they will not be considered further. Remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments in the case. The time is limited to 10 minutes. The time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions, and I'll ask that you please introduce yourself as you are recognized or come to the podium. First case for the hearing on the adopted agenda is Lynn Schmidt versus St. Mary's Community Clinical Services, E23 0123. The recommendation by the investigator is for a finding of no reasonable grounds. Therefore, we will hear from petitioner first.
And Ms. Schmidt, I think I see you. Are you LS?
I am.
Okay, great.
Can you hear me okay?
I can, yes. You have 10 minutes. Do you want to save any of that time to respond to what the respondent says? So you have 10 minutes total to present, and
Okay.
often people will save 2 or 3 minutes of that in order to respond after the other side has presented.
Yes. Does that also mean that you would be able to cut me off at like the 7-minute mark?
Yep.
That would be awesome.
Okay. Whenever you're ready, go ahead.
Okay. Good morning. My name is Lynn Schmidt, and like thousands of other Americans, I am a person who does not go by their legal dead name. During my time with CCS, I was forced to endure exposure to this name on a daily basis for the 2 years that I worked there. In their host program, Epic, as well as the knowledge that this name was being provided to every single person that I worked with, strangers that I didn't even work with, and the clients that I was supposed to be able to support. Multiple times, my clients were not appropriately informed that I go by Lynn, not my dead name, which also meant that I had to face dead naming incidences in person, in session, as well as this happening during multiple communications between peers and other coworkers. This was pervasive, as noted in the findings. I would like to remind the commission that the finding that my distress was understandable, but beyond the scope of what a reasonable person would experience. This is a reminder that reasonable people who face constant and chronic dead naming have literally died by suicide as a result. It is not beyond what a reasonable person would experience. Additionally, the way I was treated and forced to endure the continued dysregulation of being exposed to my dead name came from a place of ignorance. At CCS, the practice manager at my hire asked me directly what a dead name was. She had no idea. This was a conversation that was had at length more than once, and thus the other finding that CCS was unaware of both my disability as well as what a dead name was and the circumstances around this was also falsely found in the report. CCS tried to use the excuse that this was due to billing. However, I have been working at a new agency since August, an agency run by a person who also does not use their dead name or their legal name. And as such, they are aware of the harm of being exposed to the name and made accommodations. I can also guarantee that what CCS did to me was not due to billing reasons, because where I'm working currently, I am still seeing several of the exact same clients that I saw during my time with CCS. But the difference here is they do not have access to that name. In closing, again, I would like to state that I'm still seeing many of my clients that I was seeing with CCS. And if this was a matter of billing, my current agency would also need to use my dead name, and they don't. Thank you for your time.
Just let me write down how much time. Any commissioner questions for complainant? Commissioner O'Brien.
Good morning.
Good morning.
In regards to and I don't pretend to know exactly the ins and outs of billing systems. But but their answer, excuse, whatever, was the Epic system specifically, if I understand this correctly. So at this, where you are now, and you're seeing the same clients, do they use this Epic system? Do you know?
So I do know. So number one, that is also incorrect. It wasn't due to the Epic system, because in the Epic system, they could actually change it. And at one point they did actually change it to say Lynn Schmidt. And then they changed it back. They continued to say that this was because of billing, that things needed to line up with the name that was reflected on my licensure for billing purposes, billing of the insurance. It wasn't because of Epic. Epic could have changed it and did. and they changed it back. But the agency that I do currently work with, they do not use Epic.
Thank you.
Thank you.
Sure, David.
Are you saying that they, is there evidence in the record that they don't have to bill in accordance with your license?
There should be. When I first got my licensure, I actually did reach out to the state of Maine to confirm how that would work. And they said it was up to the agency that I worked with. And I believe in my initial finding, I included that documentation with that.
I guess I'm not sure what the answer is.
It may not be in the record.
I believe that that documentation is in the record. I believe that it should be there. Keep in mind, I also filed this complaint in like either late 2022 or early 2023. So at this point, I'm not even sure what all was filed.
Any other commissioner? Yeah, Commissioner Sanders.
Great, thank you. Good morning. Just a quick question about the structure that you're currently working within at your current employer. Do you know, does that remedy require certain kinds of manual adjustments on the back end so that in fact the billing expectations and payer expectations are met, right? So that your the name on your licensure matches the name that's being billed for services.
Is that in the record, Bob? About the current the billing system where they currently work?
No,
Okay.
Okay, great. Withdraw the question. Thanks.
Oh, okay, sorry. I was going to say I do know the answer to that, by the way.
Any other commissioner questions for complainant? Commissioner David?
Well, no, I guess it's not for complaint.
Okay. All right, so you'll have about 6 minutes and 15 seconds when we come back to you, Mike Schmidt. Attorney Howell, do you want to reserve any of your time?
no need to formally reserve, but if I have any time left over, I'll use that. Thanks.
If you're ready, go ahead.
All right, good morning, commissioners. My name's Timothy Powell. I represent the Respondent Community Clinical Services. I'll refer to that entity as CCS. At the relevant time period that this entity was affiliated with St. Mary's Health System in Lewiston. So I just want to start by saying that CCS unequivocally denies that it unlawfully discriminated against complainant or had any discriminatory animus against complainant. And the evidence demonstrates that CCS supported complainant throughout their employment. And in each of complainant's concerns was promptly and appropriately addressed to the maximum extent that was possible. Investigator Bouchain did a very thorough job with this investigation, and even after the fact-finding conference and the close of evidence, he reached out again for additional information from us about the EMR system that's central to this case, and got all the clarification he needed for his report. And at the outset, I want to be clear also, as identified in the report, there's no alleged adverse employment action in this case. CCS never took any disciplinary action against the complainant, never terminated their employment. The legal question here is whether complainant experienced harassment directed at them on the basis of gender identity or disability, that was sufficiently severe or pervasive to alter the conditions of complainant's employment. As you just heard from the complainant and saw in their objection to the investigator's report, the complaint's really focused on this issue of the legal name being used in CCS's electronic medical record EMR system. So I just want to recap from the beginning. First, CCS's policy generally is that it absolutely respects its employees' preferences related to their name, gender identity, pronoun use. CCS takes action to allow employees to self-identify their gender, name, and preferred pronouns. And CCS allows the use of preferred names to the maximum extent possible. So from the start of complainant's employment, CCS honored their request to use the preferred name Lynn whenever possible. This was done for a complainant's email address, their name badge, and there were discussions with managers and staff about the use of complainant's preferred name in in-person communication. That all happened right at the start of employment. Later on, when there was a name placard that was inadvertently placed at one of the facilities that used complainant's legal name, that issue was addressed immediately. It happened over the course of 2 days, over a weekend. They worked hard to get the nameplate changed as soon as possible. The one area where a complainant's preferred name could not be used was a matter that was outside of CCS's control. This is the use of complainant's legal name within the EMR system. So while CCS used the complainant's preferred name wherever possible, the name on complainant's medical license remained their legal name. And for legal compliance and medical records and billing requirements, the provider's name within the EMR system must match the name on the provider's license in this instance of the EMR system that CCS uses. And this is the Epic system that they use is a market-leading EMR system. CCS and St. Mary's share it with a broader hospital network. There were millions of dollars invested in this EMR system, and it's shared among many hospitals and providers. And I can't stress this enough that CCS engaged in substantial efforts to try to work around the limitations of this system to display complainant's preferred name to coworkers and patients within the EMR system while retaining the legal and medical billing requirements that were necessary. But there was just not a way to do it. This is not something that CCS just made one attempt at and then just threw up its hands. Trust me, this involved many people working on this issue. I'm not supposed to use names here, but I'll use titles. It involved complainant supervisor. It involved the director of behavioral services, the director of employee experience, the CEO of CCS, the system director of HR information systems, the clinical application analyst, and then others in the IT department. All were involved to try to make this work. And they were trying to make it work before complainant made their complaint to the commission, and then also throughout the course of the investigation, as the investigator can also tell you. And the emails that we submitted showed that all these individuals really expressed a genuine interest in addressing this issue for the complainant. And the investigator heard this at the fact-finding conference as well. And even during the course of the investigation, as you just heard, complainant raised that they had their preferred name displayed in other EMR systems at another employer, although we never saw any evidence of that. But taking complainant at their word, nevertheless, CCS immediately, right after hearing this as part of the investigation, immediately engaged in another round of trying to find a way to make it work, but it wasn't possible to do it. And complainant mentioned there was a change made. They thought they had figured it out, changed the name to complainant's preferred name. But then, of course, the problem reared its head, which is that the billing wasn't compliant and the billing got kicked back and it couldn't be billed properly. And it's worth emphasizing again that CCS conveyed to complainant that if they changed their legal name on their professional licensure to the preferred name, that name could have been promptly updated in the EMR system. Now, obviously, complainant, that's complainant's choice to make, and I'm not suggesting that is a change that should be made, but I just want to point out that if the legal name is changed, it would have been able to be changed within the EMR system immediately. So ultimately here, the complainant placed CCS in really an impossible position. Complainant uses their legal first name on the medical licensure, but then was insisting that legal name not be used by CCS for its billing and record compliance. Of course, it's complainant's prerogative whether to change their legal name or not, but it's not discriminatory on the part of CCS to use that legal name where it's required for this medical billing and record compliance, particularly where there's ample evidence in the record that in all other instances, CCS made a good faith effort to honor the complainant's request to use their preferred first name. So I'll reserve whatever remaining time I have, but for these reasons, we ask you to adopt the investigator's recommendation of no reasonable grounds for finding any discrimination in this case. And I'm happy to answer any questions you have. Thank you.
Commissioner, questions for Respondents Council? Commissioner Sanders?
Yeah, I'll ask well, first of all, good morning, Attorney Powell. I'll ask a variation on the question I asked the complainant, but again, with a caveat, only if it's in the record. I'm curious about your client's efforts to implement the desired outcome that the complainant was asking for. Did your client work through an assessment of, look, to the extent we can't change the name in the electronic medical record itself for record keeping purposes, compliance purposes, billing purposes, could there be some kind of a manual workaround, right? So could, for example, the billing team manually adjust the office visits and dates of service that complainant, the services that complainant was rendering to patients. But again, only if it's in the record.
Yeah, I believe that was in the record because I was involved in this certainly during the investigation. And I wish the answer was yes, honestly, and CCS does too. No, they tried everything they could. They work with, it's not an off-the-shelf software that they use with Epic. This is an instance, as they call it, of Epic that was developed for this whole hospital system that goes far beyond, way over CCS's head, way over St. Mary's head. This hospital system uses this, and we worked directly with. We went to the folks that are kind of behind the scenes in that working on that instance of Epic to try to do that. And you think, there's got to be some way to do this, but it's not built into that instance of Epic that they use. The one thing, as I mentioned, the one thing they were able to do was get, they thought they had figured it out and they changed the name, but it didn't work. They thought they had figured out a way to use kind of a, like to put in a preferred name that was still nevertheless attached to a legal name, and it didn't work. They weren't able to do it. I don't know if hopefully that answers your question.
Yeah, just to drill down a little bit further, I guess my specific question is understanding, right? So let's say the name, the complainant's name that they wanted, right, appears in the record, which sounds like at one point that's what CCS did. Could it have been, right, that in that case they could have left that name, and then, right, the billing team, the coders and the billers could have pushed out the claim, manually adjusting the name to the legal name. And I'm curious about whether your client investigated whether there could have been a manual intervention at the point of billing to implement the remedy complainant was looking for.
Yeah, I know that's what I don't personally know the specifics of how they did that, but I do know that that is what they were working on. That's what they were trying to do. Yes.
Okay, thank you.
Thanks.
Commissioner questions? Yes, Commissioner David.
Attorney Powell, am I understanding you're saying that, well, the question is, are all the public facing uses of her name the name that she prefers? In other words, the email, the client, the badge, the identification badge that she wears, the plaque on the door had a mistake that you rectified. Is there any other public facing non-use of her name?
No, everything outside of this EMR system issue that we're talking about. No, everything else was use the preferred name. To the maximum extent we're aware of it. And anything that sorry, yes, go ahead.
Does that include internal interactions with the employee? Meetings, yes. You've said email, references to her or meetings with her or that kind of thing?
Yes.
All use her preferred name? Yes.
So at the start of all from the very start of employment, the complainant came in and this was known, from the very start of employment, what the preferred name would be.
What you're claiming.
Sorry,
it was not only known, but it was honored
Yes,
and implemented. All right,
correct.
thank you.
Any other commissioner questions for Attorney Powell? Seeing none, you'll have about 2.5 minutes when we come back to you. Ms. Schmidt, you have 6 minutes and 15 seconds. And can I just check with you, are your preferred pronouns they or she?
So it's actually both. I'm a complicated one in that.
We can handle it, yeah. I just wanted to make sure we were using the right one.
Yeah, I appreciate that very much. Yeah. So generally speaking, how you tend to accommodate when you see that is you kind of alternate between they and she instead of just using one exclusively. So if we could do that, that would be very appreciated. But I also I understand the nuance and the complications with that. So
Perfect. All right, you've got 6 minutes and 15 seconds whenever you're ready.
So am I asking him questions or am I responding to what he just said?
You're responding to his presentation, but with facts that are already in the record.
Yes. Okay, perfect. Thank you. Okay. So one of the things that I really want to address here is his statement of at hire, these issues being taken care of. So one, during my interviewing process and during my onboarding process, this is not my first rodeo. Everywhere that I work, I am very vocal that I go by Lynn. I want this accommodation. And at hire, this did not happen. That is inaccurate. There is documentation in the record to support this. And the accommodation to transition everything in the email took, I want to say 2 weeks to a month. I can't quite remember off the top of my head, but I know that there is documentation in my complaint. I have an entire thing about when I made the complaint, when I was hired in, when things did transition. So claiming that this accommodation occurred at hire, that is incorrect. And additionally, this should be taken care of before hiring. I should not have to continuously argue with people during my onboarding portion of this. Like, it should have already been done. Additionally, he claims that within 2 days of my name being up on the board that it was taken care of. This is also incorrect. I don't actually know how long my dead name was up on that name placard before I made that complaint. And I only made that complaint because I ended up having a straight up panic attack that lasted 2 days and had to leave because, again, this is public facing information. This is what every single client saw as they walked in. So it wasn't just taken care of. It wasn't even checked in on. It was not until I complained about it that then it magically 2 days later was taken care of. Again, this is an area where it continued to display that proper communication between the agency and the higher ups was not taking place. That should have never have happened. And additionally, there was a question around the public facing entities, like could it display the name Lynn? This was also in my report that other agencies have been able to, one, still use my legal name, but what they would do is they would put Lynn in quotes and then have the legal name. And that was the bypass that they did. To my understanding, and again, this is in the record, they never even tried this. And so email wasn't the primary way that we communicated. And when we talk about the public facing entity, this means that every single client of mine was given my dead name multiple times for every single session that they had with me. Every single session. It was on every single reminder. It was on every single piece of snail mail documentation. It was on every single thing. I had to constantly correct it with many clients. And then we had an internal messaging system. That's how people could find me when my name was attached to my clients and things like that. So it wasn't just the accommodation of email that was like the primary sources of contact. It was in the electronic health system. And that's a huge part of why this was so problematic, because again, it was pervasive. It was all the time. It was to every single client for every single interaction, every single sorry, I also have a brain injury and it flares up when I'm stressed out and I'm kind of shaking right now. But it was for every single appointment that they had and every single reminder. Like there was no getting away from this on this portion. So with that, I yield my time. Thank you.
Any other commissioner questions for the complainant? Seeing none, thank you very much. Attorney Powell, you have about 2.5 minutes left.
I'll just make just one more point on the use of the name Lynn with quotes as a it's still associated with the legal name within the EMR system. That's absolutely something that the CCS was trying to do. That's especially after complainant raised that she had been able to do that in other at other employers and other EMR systems. That's absolutely something that CCS tried to implement and was unable to in this instance of Epic. I'm happy to answer any other questions.
Questions for Attorney Powell? Seeing none, thank you both. And next we will hear from Bob Beauchesne, the investigator assigned to this case.
Good morning, Commissioners. I don't have a lot to add. Again, as noted, after the fact-finding conference was done, there was still a question about whether or not there might have been some way to use the preferred name, and we requested additional information and came to the same conclusion that anything that related in any way to billing, including providing services to patients, all required that the legal name on the medical license be the one used. Again, they did attempt to honor her requests in other areas, as noted, both on email, on her name badge, and other things where the preferred name was used, but due to the pervasive nature of the billing that went on, there was nothing that indicated that there was any choice the hospital could have made that would have allowed the use of the preferred name for anything related to billing.
Bob, any commissioner questions for the investigator?
Bob, I had a question about why is disability in this case? I mean, the discrimination is alleged to be sexual orientation,
Right.
or disability, but disability would require medical documentation, would it not?
Well, in this particular case, again, complainant did self-report to supervisors and I believe HR as well that she had a particular medical condition that was exacerbated by stress. So
doesn't that have to be documented?
Again, as far as there was nothing there that the respondent requested any particular medical diagnosis or anything else. I think they took that complainant at their word that this was aggravating her condition. But again, she requested a particular change in schedule as a result of this condition, and that was summarily granted.
Okay, thank you.
We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding.
I'll move that we find that there are no reasonable grounds to believe that respondent unlawfully discriminated on the basis of sexual orientation or gender identity or disability, and the complaint should be dismissed.
Second.
Been moved and seconded. Any discussion?
I always look for animus of some sort, and I am hearing fairly uncontested confirmation that they tried to accommodate in every way they could. And I don't see how the Human Rights Commission has sufficient evidence before it to second guess the technicalities of the software and the billing system. But given all their other actions of complying with the requests, I can't believe that there's discriminatory animus.
Any other discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
So the second case for hearing is Terrence Christopherson versus Wayfair LLC. The recommendation, I think it's, give me a second to find it in my notes. The recommendation is for finding of no reasonable grounds on disability and retaliation. For no reasonable grounds on age, but a finding of reasonable grounds. A recommendation that we find that there are reasonable grounds in regards to disability and retaliation. And since the primary recommendation is that we find reasonable grounds, we'll hear from the respondent. Correct?
Yes. Right. And I'm going to ask you to please tell me how to correctly pronounce your last name.
Yes, common request. It's Susan Taverdi, representing Wayfair.
Great. And Attorney Taverdi, you have 10 minutes. Do you want to reserve any of your time?
Yeah, I'll reserve 3 minutes.
Okay. Whenever you're ready, go ahead.
So this case arises from a large-scale reduction in force that occurred at Wayfair that impacted nearly 2,000 employees. And complainant was included in that RIF on 2 neutral criteria. One, her relatively high compensation for the role in which she was in, and a recent not always meeting expectations performance review. That performance review was conducted by somebody referred to in the report as manager. She had multiple managers, but it was the most recent manager had become her manager in November of 22. And the performance review cites 2 specific firsthand observations regarding complainant's interpersonal conduct, which included raising her voice in meetings, using an inappropriate tone, and not accepting direction. These are legitimate performance expectations in the workplace. Importantly, at no point before the performance review had complainant requested a workplace accommodation, despite being expressly and informed of the available process on multiple occasions. Complainant had disclosed that she was on the autism spectrum, and in 2 different scenarios, Wayfair asked if she wanted an accommodation or referred her to contact the Employee Resource Center that handles the accommodation process, which she did not avail herself of. And this is fundamentally, I think, the most important part of this case is that employers are permitted to expect respectful and effective communication in the workplace. They're not required to waive essential job standards simply because an employee has disclosed a disability. And under the Maine Human Rights Act, while it prohibits discrimination because of disability, it doesn't prohibit a company from having job-related performance expectations. Even if that individual can't meet those expectations because of a disability, if they have not sought or requested an accommodation or gone through that process, an employer still has the ability to hold out those expectations. And so that's where I think the investigator's report gets the law wrong here, and that there should be no reasonable grounds finding on the disability discrimination claim, particularly here where there's no evidence that the manager that gave that not meeting expectations held any sort of discriminatory animus towards the complainant. Again, as for the retaliation claim, again, the inclusion in the RIF was based on neutral criteria, one of which was that not meeting expectations performance review. But again, there's no evidence that complainant's prior complaints, of which admittedly there were several complaints involving prior managers. There's no evidence connecting the most recent manager to involvement or knowledge of those prior complaints that largely occurred in the 6 months prior. And I would like to point out the manager who gave that 4 rating, or that not meeting expectations rating, he wasn't at Wayfair when the investigation came along. He wasn't included in the interview. And so the conclusion that he was influenced by prior managers is not based on evidence in the record. It's based on a conclusion, a speculation that he must have been influenced by prior complaints involving other managers. So for that reason, too, Wayfair would request that the commission find no reasonable grounds to find that retaliation occurred in this case. And that concludes my statements for the opening statements.
Any commissioner questions for Attorney Tuberty? Seeing none, you'll have about 6 minutes when we come back to you. Attorney Tart, and I'm mispronouncing everybody's last name. Remind me how to pronounce yours.
It's Tart, you got it right, thank you.
I'm sorry, what is it?
Tart, like Pop Tart.
That's gonna stick.
You used that before.
Do you want to reserve any of your time?
Sure, I'll reserve whatever I have left. If it's 3 minutes, then so be it. So thank you, commissioners. I appreciate the opportunity to talk to all of you today about Ms. Christopherson's case. First I want to point out, I think the investigator's report was spot on. I just want to note that Wayfair had the opportunity to produce witnesses during the investigation, and no witnesses were interviewed in person. There's no opportunity to actually question witnesses. Instead, what Wayfair did was they produced an affidavit of one of the managers, not the manager notably, who wrote the final performance review, just another prior manager. So, you know, the claim that we're speculating as to what this manager may or may not thought of, the only reason why we have to speculate is because Wayfair didn't produce the witness so that we could talk to the witness and figure out what the witness was thinking, what was going through the witness's mind. So I think that for that reason alone, we can't credit we could probably credit that for Ms. Christopherson. I think that goes in Ms. Christopherson's favor. I think you can infer that witness would have had unhelpful things to say about Wayfair's defense. And I think that's a totally appropriate inference to make because there was ample time to produce that witness, and yet the witness was not produced. With that said, as was noted, Ms. Christopherson has autism. Autism is a diagnosis that affects your ability to communicate. It affects your ability to socialize. It affects basically every part of how you interact with a human being. It's a very difficult diagnosis, especially in the workplace. Wayfair had a people's principle, a we win together section of their performance evaluations. Now, Ms. Christopherson was an IT personnel. I don't know if anyone has ever worked with IT before, but generally the way it works is if you have an IT issue, you submit a ticket and then it gets circulated through the IT programs and processes, and eventually an IT individual will respond to your ticket and they'll fix your IT issue. That was Ms. Christopherson's that was her primary essential duty working at Wayfair, was to address IT tickets. What Wayfair wanted Ms. Christopherson to do was to be more social, was to disclose more about her personal life, was to share personal details. And Ms. Christopherson disclosed to 2 of her managers that she had an autism diagnosis. One of those managers, the first one, basically said, look, told the senior manager, I'm dealing with a neurodivergent individual. I've seen how these folks are on TV. I'm being more lenient than I otherwise would be. So Ms. Christopherson, reported this individual for those comments. So then Ms. Christopherson gets another manager. The other manager who provided an affidavit in this case made other discriminatory comments to Ms. Christopherson, one of them during a meeting with HR, saying that she's using her disability as an excuse to not do these, to meet the requirements of Wayfair's social we win together pillar of their performance reviews. It's a very odd sort of performance evaluation that you need to be more social, you need to interact and be a team player. That's what Wayfair was expecting of Miss Christopherson. Everything else in Miss Christopherson's performance reviews relating to IT were spot on. They were great. There were no issues with her fulfilling her IT tickets or, meeting the expectations of her employer. It was just this little area of her socializing. Like in one instance, this manager wanted Miss Christopherson to share her birthday with everybody. And Miss Christopherson didn't want to share her birthday. She didn't want to be social. And yet, the manager, despite knowing this, disclosed the birthday to her team, which was something that upset Miss Christopherson. There was an HR meeting and council has kind of sort of conflated the failure to accommodate with disability discrimination. Sure, you need to actually request an accommodation. We're not saying that that didn't happen here. What happened was during the HR meeting, HR basically told her, hey, Miss Christopherson, is this something you need an accommodation for? But before Miss Christopherson could really understand that, the conversation had moved on to another point. For somebody with autism, when you're trying to explain something to them, to kind of brush through reasonable accommodation and not explain it to the employee is very problematic. And while the investigator found that, the failure to accommodate didn't withstand scrutiny, it's just further evidence that they weren't treating Miss Christopherson's disability seriously. So there were 3 managers there and a senior manager. The one manager we don't know, and this is the witness that was not produced. We do not know if that witness knew or did not know about Miss Christopherson's disability, her autism diagnosis. We do know the senior manager knew about it. We know that the other 2 managers knew about it. We knew that HR knew about it. And I think the final most difficult piece of evidence for responding is that when this manager came back on, so at first he was the first manager, and then they put him on at the end, right before the RIF. And at the end, he had only supervised Miss Christopherson during that period for 6 weeks. And during that 6 weeks, Miss Christopherson did not speak to him, did not interact with him, did not work with him. That's in the record. So what was he relying on when he came to this determination in the final performance review? What was he relying on? How did he know that Miss Christopherson was having issues socializing and meeting the we win together people's principles? We don't know. 1, because Wayfair never produced the witness. And 2, because it's 6 weeks. It's a small period of time. There was not enough time for them to really evaluate whether Miss Christopherson was socializing and meeting this we win together pillar of the performance review. And so as Wayfair acknowledges, their RIF, they used 2 criteria to determine whether to select an individual for the RIF. The latest performance review and compensation. So there's 2 factors there. One of them is objective. One of them, the performance review, especially their social skills, is highly subjective. And so Wayfair relied on that most recent performance review in selecting Miss Christopherson for the RIF. And so I guess the question that we need to ask ourselves today, whether there's reasonable grounds, is does Miss Christopherson's disability diagnosis make a difference? If you take that out, if you take that diagnosis out, and which affected the performance review, the We Win Together performance review, if you take that out, is there a different outcome? And I say there is. I say if you remove the disability diagnosis, I say if you remove the final performance review, I say that Miss Christopherson would still have a job today, and she doesn't. And so the standard here today is an even chance at prevailing. It's very rare in a RIF case that we have the kind of evidence that we have here. Again, Wayfair did not produce that witness and they should have. And I think we can infer that that witness would not have had anything helpful to say for the respondent. So with that said, I yield my time.
And some 20 seconds when we come back to you. Any questions for complainant counsel?
You mean me?
Yes. Oh, nope. Commissioner Douglas has a question for Attorney Tart.
Yes, thank you. Attorney Tart, good morning. Can everybody hear me okay?
Yep.
Yeah, okay. So you just said, how would it be different, right? If without the diagnosis. And I'm looking at Wayfair's statement and the gist of it, and it's somewhat compelling, is that there were some pretty serious performance issues here. right? Cited for raising her voice in meetings, using inappropriate language that made colleagues uncomfortable, resisting direction and feedback, needed to work more closely with others and engage more collaboratively with cross-functional teams, repeatedly disrupted team meetings by openly rejecting workflow changes and resisted basic managerial expectations, including participation in one-on-one meetings, and so on and so forth. And, and then the submission points out that, when offered a chance to explore the accommodation, she took no action. So I think the gist of this of Wayfair's submission is that the employer is, regardless of the disability, the employer is entitled to take into account these these deficiencies in an employee's performance. And I wanted to give you an opportunity to sort of respond directly to that.
And you know what, that's an interesting point you raised. That's one way of characterizing what happened through the facts of this case. You could characterize Ms. Christopherson's conduct like that, but the truth of the matter is that those statements and those things that were being said by Wayfair, those all related to Ms. Christopherson's reports that she had, this disability, that she had autism and she was struggling and her managers weren't taking it seriously. They were bullying her. She reported it to HR. I think it's easy to kind of get lost in these vague terms about raising her voice, but we don't have any witnesses elaborating on any of that. We have no witnesses in the record, none. None showed up to talk to the investigator. None of them did. Wayfair could have produced those witnesses. Wayfair decided not to produce those witnesses. Instead, we have an affidavit. Ms. Christopherson showed up. Ms. Christopherson explained how a lot of these interactions were because of her disability, and they were because she was reporting and opposing the harassing conduct of her managers. And I think that's clear from the record. If you listen to the recording of the HR meeting between Ms. Christopherson's managers, the senior manager, one of the managers in HR, you can really get the sense that they're ganging up on Ms. Christopherson, and they're saying that you're using your disability as an excuse. You can't do that. When this accommodation request gets brought up, Wayfair makes it seem as if that they sat her down and they said, you can get an accommodation. Okay, that's not how it went down. All right, what really happened was they said to Ms. Christopherson in a very quick manner, hey, you can go get an accommodation. And as Ms. Christopherson explained to the investigator, she was confused about what an accommodation was. She was thinking about a physical handicap, about a physical disability, something visible that we all see, like a wheelchair and needing a ramp or something of that nature. She didn't understand that she could possibly have this accommodation that would excuse her from doing these strange social events that Wayfair asks of its IT personnel. And really what this comes down to, if you read the We Win Together section of the performance review, it's really about socializing. It's really about being a team player and interacting. Ms. Christopherson just wanted to do the tickets. She wanted to work. She didn't want to be bothered by doing these things like a peek at you, where you share your personal details of your life. That's one of the things that they were asking her to do, was to share the details of her life, her birthday, her hobbies. One of the managers said, if you don't do this, people might think strange things of you. Like these are not things that are appropriate to ask of somebody with autism. And the company struggled every which way in addressing how to deal with Ms. Christopherson's disability. And I think that if you look at the prior performance reviews, they're all wonderful. You get to this last one of a manager who managed her for 6 weeks, had no interactions with her, and just says, you know what, you've had really poor, you haven't been working well with the team, you're not socializing well, so I'm going to dock you on the We Win Together. And he had no as far as we know, because again, they didn't produce the witness, he did not observe that. So where did he get that information from? I think you can reasonably infer he got it from the other managers who clearly harbored animus about Ms. Christopherson's disability.
Okay. All right. Thank you.
How long did she work there?
I don't have the answer right off the top of my head, at least more than a year. Probably we have a performance review, I believe, going back to at least 2022.
Would it be sufficient to include her in the RIF just on the high compensation?
Well, maybe. But the thing is Wayfair, they said these are the two factors that we relied on: compensation in the latest performance review. Compensation, sure, I mean, it was.
So your argument is that if it's discriminatory, if that's part of it, that doesn't give them a pass on the other legitimate criteria.
No, it doesn't, because we don't know if
Am I right that that's the argument?
the argument, just to state it clearly, is that they provided two reasons for selecting individuals for the RIF. Okay, one of them is objective, the compensation. Okay, the other one is subjective, the performance review. They relied on both. That's what they're saying, that they relied on both. One of them was tainted by animus. And so if you take that out, would it have made a difference? That's the question. And I think an even chance, a coin flip, yes, we would prevail. And I think that a fact finder could reasonably conclude that had they either accommodated her or had they not dinged her for that social part of the performance review, she could still have a job today.
All of this takes place before knowledge that the rift is coming, correct? In other words, that you're not saying that the discriminatory behavior is in order to put her into the rift. They don't know about the rift.
Well, we don't know what they know because, again, the witnesses did not come and testify to the investigation.
Not from the record when the rift
We know,
was disclosed to the management.
we know what true. I mean, I believe the record, if I'm remembering it correctly off the top of my head, was that at some point the managers became aware of it. But it wasn't, I don't believe that it was during the HR conversation between Ms. Christopherson and her managers. It probably would have been after that, but I don't know. I can't recall.
The thing I stumble over is why she didn't request the accommodation, and you've addressed that, and I hear what you say. My last question is, should we be hearing comparison to other IT workers in how, and does it make any difference whether any others of them were included in the rift or not? It's obviously not in the record.
It's not in the record, and
It's not in the record that we probably shouldn't regulate about it.
Well, you could argue that we should have, I mean.
right, perhaps.
Okay, thanks.
Any other commissioner questions for the board? Back to respondent, you have about 6 minutes.
Thank you. Just quickly to hit on a few points. I know much was made of the witnesses here. I'll say when the fact-finding conference was coming up, the investigator reached out and one of the witnesses that remained had a scheduling conference. And so the investigator requested an affidavit, and that's what Wayfair submitted in response. The most recent manager, again, was no longer with Wayfair, and we couldn't get scheduled in time for the investigative conference. I just point that out to say it's not that there was hiding of witnesses or cooperation. So that's what occurred there. In terms of casting the we win together principle as a socializing principle, I think that the record reflects otherwise. It's clearly a principle grounded in collaboration and being able to work in an environment with other people. And Wayfair's concerns about the we win together principle were legitimate, following managers' instruction, following changes in workflows. These are not asking you to go to a party after work. These are very basic workplace expectations and instructions. And as for, comments that other managers made, I want to point out, I don't think the record reflects a manager saying, I've seen how they are on TV. But there's nothing in the record reflecting that the most recent manager who gave the below meeting expectations performance review made any kind of concerning comments about complainant, held any sort of discriminatory animus towards complainant. And while the complainant declares that she had no interactions with that manager, the performance review reflects otherwise. The manager cites two specific examples, cites to interactions with complainant. And it would be quite unusual for a manager not to interact with a direct report over the course of 6 weeks. And finally, the record does reflect, it might be early on, that other individuals of complainant's same in her same position were included in the RIF. That was a part of analyzing the age discrimination element of this early on, that I think then reflected that there could be no age animus here because of the number of people under 40 that were included that were in the same position. So I think those are the primary points I want to make here. I think at the end of the day, it is a question of what scenario is Wayfair put in here, in that there are legitimate performance expectations held. There is reference to seeking, giving complainant information about seeking an accommodation. There's in that meeting, there's also the affidavit from the other managers referring complainant to the Employee Resource Center, those not being availed of, and then Wayfair trying to hold expectations across the board as it would for any employee. And the law just simply doesn't require an employer to lower or relieve employees of those legitimate performance expectations simply because they've disclosed a disability if there's not an accommodation request in process or that's been denied. And that concludes statements.
Any commissioner questions for Attorney Tardy? Being none. Attorney Tart, you have 2 minutes and 20 seconds if there's anything else you'd like to do.
Yeah, I would just want to respond. So the 6 weeks, the comments that the final manager made about having interactions with Ms. Christopherson, we seriously dispute that those interactions occurred with that manager. We feel that some of them were from prior managers. Ms. Christopherson, when she showed up and did the interview, said that she had minimal to no contact with this final manager. And, just in terms of the law, there's subordinate bias and cat's paw. We all know that if a neutral manager relies on another subordinate manager's biased or animus comments or critiques, if the manager relies on those, then there is liability under subordinate bias. It's very well known, and we feel that that's probably what happened here, that during that 6-week period, the final manager needed to write the performance review and relied on the prior comments of not one, but 2 prior managers and a senior manager who knew about Ms. Christopherson's diagnosis and Ms. Christopherson's reports of those diagnoses and the HR meeting where they were all there together except the final manager discussing it. Again, the affidavit provided by the one manager that did provide an affidavit, I think some of that is rebutted by, the recording that we provided of the HR meeting that Ms. Christopherson took and submitted to the Maine Human Rights Commission. And so with those things, we feel that there are reasonable grounds. We do feel we have an even chance, a coin flip at prevailing in a civil lawsuit. Thank you.
Other questions for Attorney Tart? Seeing none, thank you both. And next we'll hear from Bob O'Kane, the investigator assigned to this case.
Commissioners, I think the parties have covered their respective arguments pretty thoroughly. Again, here, for me, the record reflected that on 2 occasions, she disclosed her disability to a supervisor. In both occasions, within a short time thereafter, supervisors filed complaints against her with HR. So there did appear to be some animus there, as well as has been noted. One of the supervisors specifically made the comment that they believed she was trying to get out of having to meet expectations by using her disability as an excuse, which was pretty clear to me. They did not request additional information at that point to make sure that that was in fact what was going on here. Rather, they simply accepted her at her word. But again, in both circumstances, those supervisors ended up complaining against her shortly after the disability was disclosed. With respect to the RIF, there were actually two that took place in this case. One earlier that year, I believe 6 or 7 months earlier, where a wave of employees was let go. And then again at the end of the year, and that was the one that affected the complainant. With respect to the last manager, again, there is a dispute about whether or not any meetings or any interaction whatsoever took place during that final 6 weeks. Yet the final performance evaluation speaks directly about complainant having communication issues at meetings. And the only source where that information could have come from was from the prior supervisors. So there was the fruit of the poisonous tree, or whatever you want to call it here. There was impact made by the prior supervisor that clearly influenced the final manager's determination as well. Complainant had never had a fail to meet expectations on any prior performance review before that final one that was used as justification for letting her go.
Any commissioner questions for the investigator? Commissioner David.
Bob, is there any significance to the two different RIFs and the fact that she's not picked up in the first one, but is in the second?
Again, I don't think whether or not she was kept on board at that point because of her technical skills. It appears, again, this was company-wide. It wasn't just a particular area around the country or a particular job classification that was impacted. There were wide-ranging thousands of people that were let go, which made it difficult.
At that point, it's automated in a sense, who gets picked up. And the argument is that it was the discrimination that created the bad reports that are sitting there that then include her in the two criteria against her, one the bad report and one the high compensation.
Right. So again, as we noted, we were unable to pinpoint the actual individual that had the ultimate say about letting her go or not. So all we could really go by was the information in the final evaluation that, again, did speak negatively about communication skills, which she had established earlier were the major issues she was having with the prior managers. She didn't enjoy sharing her personal life or details with people she worked with. She simply didn't believe that was necessary to perform her job. Yet there was a pushback from both supervisors that she needed to become more part of the team, and that by sharing personal details, that would somehow bring them closer together as a workforce. So if the communications were spoken about negatively in the final evaluation, issues to her disability, that was enough for me to be able to say that's an even chance were this matter to go to trial and we get more details about what factors were considered.
Any other commissioner questions for the investigator?
I did have a question about the disability. You start by saying that she has a disability that is not related to that is, I don't know what the phraseology is. The severity doesn't matter. It's severe per se, just because of the name of the disability, right? How do you know that she has that disability?
Again, I have no reason to dispute somebody's. It would be hard to see how she would have much to gain by feigning a disability to try and get special privilege at work, and rather, and I know this.
It comes from her.
It did.
Yeah. Okay.
The information came from her, and
because she doesn't file a request for accommodation and submit documentation.
And that's been made a point as well, whether or not she had an obligation when offered that possibility of seeking an accommodation, whether she should have followed through on that. But in this case, the only accommodation she was truly seeking was to not be disciplined for manifestations of her condition that she couldn't control.
Well, it makes more sense that the disability is directly in conflict with the policies of being social and disclosing private information. That's a symptom of the Asper.
That's what she was suggested as well, that it's simply, in this case, I don't have the ability to do that. And the interactions, even limited, that we had during the fact-finding conference itself, I have no reason to doubt that there were communication issues, although she was certainly able to convey the answers that I needed.
Any other commissioner questions for the investigator? Okay, good night, thank you, Bob. We've heard from the parties and the investigator. At this time, we are looking for a motion. There are proposed findings.
Yeah, I'll move that we take all these findings together, and that we hold that there are reasonable grounds to believe that Wayfair unlawfully discriminated on the basis of disability. There are reasonable grounds to believe that Wayfair unlawfully retaliated against complainant for engaging in WPA and or MHRA protected conduct. And there are no reasonable grounds to believe that Wayfair discriminated against complainant on the basis of age.
Yep. Moved and seconded. Any discussion?
Yeah, I would just say that, I think that Wayfair has made some compelling points in its submission and in its argument today. I just feel that the even chance standard is in play here, and I think the these findings reflect the fact that there's an even chance, or not an even chance, that complainant will prevail on these three claims. So.
Yeah, agree.
Any further discussion? Seeing none, the motion is to accept the investigator's recommended findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are split: reasonable grounds on disability and retaliation, and no reasonable grounds as to age. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
Yes, we'll be in recess for 5 minutes.
Great.
So we'll hold the meeting to order. The next case is Patricia Hall versus Hometown Health, Newport, PA 230152. The recommendation is for finding of reasonable grounds, and therefore we would hear from the respondent.
Right. Attorney Uwar, you have 10 minutes. Do you want to reserve any of your time?
I'll reserve whatever I have left.
Okay. And also please tell me if I am mispronouncing your last name.
It's come, it's where, just like where are you?
Where? Okay, great. That's actually very helpful because there are a lot of you who practice at the commission with the same last name. So I'll keep that in mind. All right, whenever you're ready, go ahead.
Thank you. Good morning, commissioners. My name is Matt Ware and I represent the Respondent Hometown Health Center. I don't have too much to add other than what we've already outlined in our submission. Respectfully, we believe the investigator misapplied the law. And at the end of the day, the commissioners should not accept his report and instead find that there were no reasonable grounds to find discrimination. With that, I'd be happy to take any questions the commissioners might have.
Any commissioner questions for Attorney Ware? Okay. Seeing none, you'll have 9 minutes and 30 seconds when we come back to you. Ms. Hall, that. You have 10 minutes. You're fine. People often are. Don't worry about it.
On February 14th, I went to my doctor's office for a regular visit, as I always did, brought my dog into the kiosk. The waiting room was absolutely crowded. And before I even had a chance to sit down, one of the girls from behind the office came out and asked me if Zoe was a service dog. And when I first started going there, like 5 years before that, I had spoken with the lady behind the desk and gave her a card, a certification card, and said, she's a service dog, this is what she does. So he said, okay, I'll make a copy, put it in your file. And if anybody ever asks you again, is she a service dog? That's all you have to say, yes, she is. And the copy's in my file. Well, this particular, she went back, the girl went back, tried to find the copy, came back out and told me she couldn't find anything in the file. And I gave her a copy of the card again and asked her to copy that. And she took that and went back into the back and came out again and asked what the service was that she provided. And I told her that she would alert if I went down from anaphylaxis due to a medication I took. And she asked me what medication it was and who prescribed that medication. And I was like really begrudgingly telling her these answers because I felt it could have been handled in the back when I went in for my appointment. But I was just felt like I was being bombarded and stuff. I don't handle confrontation well. So I felt like I was being bombarded and I just gave them the answers. I just want my day to go clear, go nice and quietly. It was a little while before I went back for my appointment. My doctor came out into the room and said, I'm sorry for the commotion out there. The bigwigs are here today. And then she said, and I know that Zoe's been coming here for 5 years. We've never had a problem with Zoe. But they say that you have to have a letter written by your pulmonologist because you take the medication by your pulmonologist. And you have to have that letter in your chart before you can come back again. And I told her I thought that was wrong. I didn't think they could say that, but I would talk to the pulmonologist and see what she had to say. I called my pulmonologist. I won't go that far. What she had to say, and she said, well, I walked out, I left and it was a normal. I said, but I don't think they can do that. I don't think they can say that. So I said, I'll ask the pulmonologist. I asked the pulmonologist by phone to call me. Her assistant called me and I told her what was going on. And she said that she would talk to the pulmonologist and get back to me. And I didn't hear from anybody for a week or so. So I called back and said, I don't understand why, what's the delay? And she said she doesn't want to write a letter because it's against your rights. to have a letter in your file because she's a service dog. That's not necessary. You don't have to have that. And that's why I won't go on board with it. And that was the end of it. And they had told me when I left, the doctor's visit on the 14th, my doctor told me, well, without that letter, you can't bring Zoe back in as a service animal. And that's how I left it.
Any commissioner questions for Ms. Hall? Seeing none, you'll have about 6 minutes and 22 seconds. If you want to sit down, we'll ask Attorney Ware some more questions.
Thank you.
Ask Attorney Ware, I guess, if he has anything else. You've got 9 minutes and 30 seconds if there's anything else you'd like to add.
No, I mean, I think we've covered largely some of the points of disagreement in our submission with respect to the facts. I think the parties have divergent views, and I think the investigators' findings depict this with respect to the conversation that occurred in the primary care physician's office and what was told to Ms. Hall by her primary care physician. You know, our position as laid out in our submissions is, you know, there was never a statement whatsoever that she was required to receive that letter to come back to her appointment. As the record clearly reflects, and as Ms. Hall just mentioned, she had been a patient at the facility for quite some time. And so we categorically would deny that any requirement or any statement suggesting that it was a requirement to receive a letter from her pulmonologist occurred on the 14th. I think also there was some discussion from Ms. Hall early in her statement to the commission with respect to the interaction up front with some of the staff. And I believe I heard, but I could be mistaken, that she mentioned that one of the staff members asked her some additional questions with respect to her health condition and some of the medications that may be implicated if she were to have an attack and need the utilization of the service animal. Again, I think the parties have very different views as to the course of the conversation out front. And I think the investigators' report reflects that the initial questions by staff were appropriate. So with those additional points, otherwise we'd rest in our submission. And I'm of course happy to answer any questions the commissioners might have.
Any commissioner questions for Attorney Ware? Commissioner O'Brien.
These clearly are different versions. So are you maintaining that could you explain the home, I can't say the word.
Pulmonologist.
I still can't say it. Thank you. I still can't say it. That conversation it did not happen?
No. So as we laid out in our submission, the respondent's position on the fact with respect to the conversation between Ms. Hall and her primary care provider was her primary care provider mentioned nothing about bigwigs, nothing about requiring a letter from her pulmonologist. As I think Ms. Hall laid out in her initial submissions and stated at the fact-finding conference, she was upset after the interaction with staff out front. And I think she was upset when she went back to see her primary care provider. Our position is that, you know, in an attempt to calm her down, an attempt to, you know, have a conversation with her and make sure she didn't feel in any way singled out by the respondents, you know, 2 legally appropriate inquiries up front. She just mentioned in passing, you know, if you want, you can get a letter, but it was no way in any shape or form a requirement, no suggestion that if a letter was not received, she could not continue. And again, Ms. Hall was a well-established patient who I think the record reflects had a very good relationship with her primary care provider.
Thank you.
Any other commissioner questions for Attorney Ware? Seeing none, we'll go back to you, Ms. Hall. You have 6 minutes and 22 seconds. Whatever you'd like to.
Firstly, what I'd like to say is, why would I make this up? Why would I go to a doctor for 5 years who had never had a problem with, never had an issue with, she never had a problem with me, never had an issue with me? Why all of a sudden would I make up this story that they told me I had to have a letter? Where would I come up with this? They told me I had to have a letter in order to bring the dog back. That's it.
Any commissioner, oh, hang on just a second.
Sorry.
Any commissioner questions for Ms. Hall?
Did you go back with the dog?
No.
No.
No, I had to go
Because
find,
they
I had
said
to
that.
find another doctor. And that took me 4 months. And I'm a person who's chronically ill. My lungs are bad. I have to have a doctor. I can't be without a doctor. I wouldn't say that my PCP said you have to have a letter in order to come back and the bigwigs were there. I wouldn't have said all that if it didn't happen. I don't make things up. I'm,
Thank you.
yes.
Right, so we have heard from the parties and council. We'll next hear from Bob O'Shane, the investigator assigned to this case.
Who's he?
I know, Bob, I hope you're reading.
Getting a little parched. All is well. Again, just really 2 points. Number one, there is a dispute about whether or not the letter was described as a mandatory requirement to continue service with that agency. Again, complainant has been adamant that it was do this or else kind of thing. But even taking the lesser stand of suggesting that she obtained the letter is violative of the act in and of itself, simply to make their job easier next time. She was being asked to provide something or suggested she provide something she wasn't required to do. The law allows the 2 questions and no documentation is required. So whether or not this may have made it easier for the doctor or other staff, it's still nothing that's required under the law. Again, and the fact that it's characterized as a suggestion versus a mandatory requirement really doesn't make a difference in this particular case because they were still asking for something that the law did not allow.
Commissioner Sanders.
Good morning, Bob. Just a quick question about the basis upon which you've made one of your findings of fact. In your investigator's report, page 3, it's section 3E. You make the finding of fact, quote, after the interaction with staff, complainant met with the FNP for her exam. FNP told complainant that she would need to get a letter from her pulmonologist regarding her need for a service animal, and that while she, in parens, FNP, did not agree with the letter requirement, unidentified, quote, bigwigs, end quote, required the letter for complainant to return with her dog. Can you say more about how did you make that credibility determination in the absence, right, of documentation, for example, in the patient record about what exactly happened? I'm curious about that piece.
Well, number one, again, I think as the you may have observed, complainant was very credible in her presentation of both facts at the fact-finding conference and in her answers. So nobody will know whether or not that statement was made or not. But again, we're still getting back to even if merely the suggestion that she provides something she was not legally required to provide. If you have to decide who is most likely telling the truth there, there's very little the complainant would have had to gain here by gaming the system and inventing this dialogue that never actually occurred. She had been a longtime patient there, and for her to not come back after her doctor apparently told her that this was illegal to even ask for the letter, it just didn't make any sense to me that she would have concocted all this to bring about that much more headaches for her, having to find a new doctor and the other things. So again, I guess ultimately still relied upon the fact that the suggestion, which is not disputed, she admits to making that statement that if you want to make things easier in the future, you just get this letter, we'll keep it on file. So again, for me, it just didn't seem logical that she would have concocted this entire dialogue about the bigwigs and whether or not the letter was in fact required or not, and then gone to the trouble of having to find another doctor after she had been treated there for 5 years. It just didn't make sense that she would have, or if she was, she could. Again, here, I'm still going back to the suggestion in and of itself. So it wasn't necessary for me to resolve that question because just the suggestion itself was violative.
Can I ask you, Bob, just a quick follow-up and only if it's in the record? On the question of the credibility determination, did the provider, the respondent in this case, give you any information about how it trains its staff to navigate the question of service animals being on site with patients who are accessing care at the facility? Did you get any information about that, policies, training schedules, things like that?
There is a policy that is part of the record. Offhand, as far as, again, I would have to assume that the guidelines complies with the law, at least in written form. But again, in this case, it was not the questions that were being asked, whether they were within policy or not, again, didn't make a difference in this case because she was still being asked to provide something she wasn't required to provide.
Okay, thank you.
Any other commissioner questions for the investigator? Thank you, Bob. We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding.
Go ahead.
Go ahead. All right,
I'll
Commissioner
move
Davis.
that we find that there are reasonable grounds to believe that the respondent discriminated against complainant on the basis of her disability, and conciliation should be.
Second.
Moved and seconded. Any discussion?
Just that I found the complainant to be extremely credible. No reason to be nervous. I think it was I think it was pretty clear cut to me.
Any further discussion? Seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner Davis?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the result of the hearing.
The next case for hearing is E230154A, Gary Upham versus Regional School District 40. Is there any way to combine the argument?
Yeah, so Attorney Trenholm, I see you're with us. I have not seen complainant. So you all may have noticed from the submission of disagreement in this case that it was unclear to all of us whether the complainant was trying to withdraw his complaint or
Right.
whether he was making a submission of disagreement because he made his submission of disagreement on the withdrawal form.
Oh, yeah.
And we had these cases listed separately because they're against two distinct entities, but they are both represented by Attorney Trenholm. If complainant is here, I would suggest that we take these together if Attorney Trenholm is amenable to that, but I also do not see Mr. Upham. Is there anybody here for Gary Upham?
Well, I'll make a motion in both cases, both docket number, this docket number and E230154. I'm sorry, E230157. No, I had it right.
You're right.
I'm too far away from my list. 154B against Unit 13. Then in both cases, we find that there's no reasonable grounds to believe that those respondents discriminated against complainant, and the charge should be dismissed.
Second.
Moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds in both E230154A and E230154B. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds in both cases. Attorney Trenholm, I appreciate you being here. I apologize for the confusion. And we will send a letter to the parties and the council confirming the results of the hearing.
Thank you.
Next case is E230157, Crystal Thomas versus State of Maine Baxter Park Authority. The recommendation is for a finding of no reasonable grounds on both counts. And therefore we would hear from complainant.
Attorney Aiello, good morning.
Good morning, commissioners. Good morning, staff. I'm Kristen Aiello. I'm here on behalf of my client, Crystal. It's actually Tom's. And if I could please reserve 2 minutes, that would be great.
Are you ready? Go ahead.
Okay, thank you. Good morning. I'm Kristen Aiello and I represent Crystal Toms. I'm here because there are reasonable grounds to believe that Crystal was discriminated against because of disability, and the investigator erred in finding otherwise. In 2021, my client was the top candidate for interpretive specialist at Baxter State Park in the competitive field. She was the #1 choice and respondent hired her. She came to the job with experience, education, and passion for the work. Her performance evaluation showed that she was able to do her job and do it well. On May 20th, 2022, after having been hired in January of 2022, Ms. Toms experienced symptoms of anxiety during a routine hike, which caused her to take a small break. Her supervisor reassured her that hiking is a small part of the job and shouldn't be a problem, and it really was something that she did anyway, so she wasn't particularly concerned about it at that moment. But on June 16th, 2022, HR director in Augusta, and I'll just break there for a second and say there are several HR directors, there are several layers of folks, HR director in Augusta, HR director and HR manager in Augusta, and then HR administrator in Millinocket were all involved apparently. But the HR director in Augusta informed my client that she needs to request reasonable accommodation because of an underlying health condition, quote unquote. My client asked for an extension of probation so that she could meet whatever requirements they had not articulated prior. Respondent directed her to make another request for accommodation and sent her new forms. At her local HR suggestion, she asked for a gradual increase in hiking. But here's where concern certainly rises. In response, HR in Augusta imposed a requirement that Ms. Toms complete a series of 6 time-tested hikes and informed her that she would be terminated if she did not complete them by the end of the season, by the end of her probation. The time tests were not related to an essential function. Timed hiking was not an essential function of the job of interpretive specialist. Ms. Toms completed 3 of the 6 hikes in addition to her duties. She was injured prior to completing the 4th hike. It was the end of the park's hiking season, and her provider recommended a pause so that she could heal. The park was literally closing in about a month, so it wouldn't be an undue hardship for her to heal. Rather than allowing this pause, respondent terminated her just days later because of her disability. Although Ms. Toms' provider invited questions and she provided a note, respondent never engaged, they just terminated. So unfortunately, the investigator made some errors in interpretation of the law, which we believe led to their erroneous recommendation of no reasonable grounds. First, the investigator erred in finding that the timed hiking tests that respondent imposed on Ms. Toms were a reasonable accommodation under the law. They were not. These were time trials set by HR staff in Augusta, untethered to Ms. Toms' job duties as interpretive specialist. As we know, reasonable accommodation is the cornerstone of the ADA, and it's in the same requirement in the Maine Human Rights Act. It's a modification or adjustment to the work environment or manner or circumstances under which the position is customarily performed that allow a qualified individual to perform their essential functions, or to ensure that equal benefits or privileges. This timed situation where there are 6 hikes that are timed and GPS rated were not essential, and this was a punitive action. She was under threat of termination if she didn't complete it by the end of probation. Second, and relatedly, the Maine Human Rights Act explicitly prohibits the imposition of tests in this regard or other selection criteria that screen out individuals based on protected class. By imposing timed hiking tests on Ms. Toms, especially when timed hiking is not an essential function of interpretive specialist. And by threatening Ms. Toms with termination, respondent violated the Maine Human Rights Act and the ADA, which has the same requirement. Again, this was in writing where respondent said, if you are unable to complete the plan that was outlined, then it would be considered that you failed your initial probation. At that point, we have to look for a reassignment as part of the ADA process. Third, the investigator failed to find that Ms. Toms, a qualified individual, was terminated in violation of the Maine Human Rights Act. The investigator conceded that complainant's disability was a substantial cause of her discharge, but erroneously concluded that her discharge occurred because Ms. Toms could not perform the essential functions of the job. So I just want to stop right here and say there is no evidence that Ms. Toms could not perform the essential functions of her job as she had been doing, as she had been reviewed by the respondent in her job criteria. And there's no suggestion that she couldn't do the essential functions from respondent up until this point where she was injured and her physical therapist wrote a note saying she needed a pause on hiking in order to heal. She had a physical injury that required treatment. That she requested accommodation to be excused doesn't mean that she was not able to perform the essential functions. If this were the case, then anyone who asked for leave, for example, for a disability as a reasonable accommodation would be deemed unable to do the job. This is not the way it works under the Maine Human Rights Act and the ADA. Further, my client had been employed for almost a year. She had been meeting or exceeding her job duties, and she was fired when she asked for accommodation for time to heal from an injury. This goes against the employer's own interests here when you have an employee who's trained, who's doing the work, who's been adjudged to be able to do the job. She was hiking at the time. She was completed 3 of 6 hikes. The park was closing. It wouldn't have been an undue burden to allow her time to heal, and yet respondent went ahead and terminated her. It would not have been an undue burden. And fourth and finally, we believe the investigator erred in finding no reasonable grounds to believe that respondent retaliated against Ms. Toms. As the commission is well aware, a prima facie case of retaliation requires showing that an employee has engaged in protected conduct, she experienced an adverse employment action, and that there was a causal connection between the two. Timing is pretty prime evidence of a causal connection. So here, my client engaged in protected activity when she asked for accommodation to be excused from time hiking due to her injured leg and hip. Ms. Toms' treatment provider made the request, please excuse Crystal Toms from timed hikes until further notice due to medical condition. She will attend physical therapy and reevaluate at a later date. Please feel free to reach out with any questions. Unfortunately, just days after Ms. Toms engaged in this protected conduct, respondent who accepted Ms. Toms' request as a reasonable accommodation informed her that she was terminated. So
that's 8 minutes, just so you know.
Thank you. We believe that there is an even chance, certainly, the complainant will prevail in a civil action, and we ask you to find reasonable grounds. I'm happy to answer any questions.
Commissioner David.
Attorney Aiello, good morning. Do I understand that you said at the beginning that she sort of makes an election as to whether she wants to ask for additional time under probation or wants to make a request for an accommodation?
Yes, the way it worked as far as the timing went on that request, on May 20th, she had the interruption in her hike. On May 24th, she asked the interim director, she reached out and said she loved her job, she wanted to do her job. He suggested that if she hikes to Chimney Pond or Russell Pond by the end of the season, she could stay in her position. And then she asked at that point, she heard nothing from respondent until June 16th when HR director told her that she needs to request reasonable accommodation. It was an unfriendly and hostile interaction, unfortunately. My client after that asked for an extension of probation. She wasn't sure what to ask for. On July 5th, she made that request. There was, and I don't know if you're getting at a dispute between whether or not that was granted. But I will say that my client was told that she needed to ask to fix her request on July 20th and make another request. And that's when she made another request for a gradual increase in hiking. I hope that answers your question.
Yeah. Another question, you didn't mention in your presentation what you say in your submission. You emphasize that hiking is not a part of the job description. What is the significance of that?
Well, I'm not sure that I said hiking that explicitly, but I will say
timed hiking or
yes. Timed hiking is absolutely not anywhere listed as an essential job function. In fact, timed hiking, the respondent admitted, the natural resources director admitted that my client, they would still be able to do her job functions if she performed hiking at a slower than average pace. So that was on August 30th, an email that was produced by a respondent when asked, when they were trying to work out this plan to do this series of tests. So it is unequivocal that timed hiking was not an essential function of this job.
So we don't know whether she completed that one, a hike to Russell Pond because that was superseded by the HR saying, no, this is the program that you have to follow, the 6 hikes, right?
That's right, Commissioner. She was told after that conversation with interim director, she was told that she was going to have to complete these 6 hikes or be terminated. So that's what she focused on.
She never has a chance to because of the end of the season and her injury, right?
That's right, Commissioner. And unfortunately, the amount of time that respondent took to respond to my client, it was a month after she asked, I think it was the beginning of August, that she asked for accommodation, and on August 5th, and she wasn't told about this plan until September 2nd. And by that time, it gets pretty icy up at Katahdin on the mountain. And it was, she was left scrambling and fearing losing her job because she was being forced to comply with these timed trials, which in fact, that's what they were.
Thank you.
Thank you.
Commissioner Douglas.
Yes, Attorney Aiello, good morning.
Good morning, Commissioner.
Yeah, you described these timed hikes as punitive, and I'm looking at the record here and I'm just not sure I agree with that characterization. I mean, isn't it reasonable for the park to want complainant to respond to be able to complete these hikes within a certain period of time? And just to sort of flesh out my question, I mean, I'm looking at the investigator's report. It took her, I mean, these timed hikes, yeah, but it took her a long time. I'm looking at paragraph K. On October 2, 2022, complainant completed her second step 1 hike. She hiked for 4.25 hours and rested for 3.5 hours. She rested almost as long as she hiked. And there's sort of similar numbers for the other ones. And my question is simply, isn't it reasonable for the park to want these hikes completed within a certain period of time? Not like she's sprinting up and down the park like a rabbit, but like, and it doesn't seem like, and sort of a follow-up question, which I'm going to ask now, it doesn't seem like she failed these time trials, right? She was allowed a lot of time, right? And she spent a lot of time stopped, completed the hikes, and it seemed like that passed muster under whatever the timing requirements was. So I'm not sure why they're punitive.
Sure, I'd be happy to answer that. First of all, as far as the timing goes, there was something that was going wrong with the GPS system. That's why her supervisor went with her on that last hike, that she made it very close to the top, but they turned around. So it's, and in addition, my client would talk to people when she was going up. She talked to other hikers. She would engage with people. And so that might have slowed her down. I think that's a positive thing. And I guess what I would say in response to that timed hiking situation, if she were a member of a search and rescue team, I think what you're saying would make sense, and it would have to be explicitly stated in the job description what was required. But here, there's nothing in the job description except be able to travel in rugged backcountry, or words to that effect. There's nothing about timed hiking. There was nothing raised about timed hiking or even hiking during the interview process. So I think that respondent, in addition, by just coming down on her and terminating her in the manner in which she did, in which they did, they treated her differently than they would other employees. Who, might have an injury, and it would be hard to believe that the employer would just go ahead and terminate. But that's what they did. They didn't, and I guess they didn't raise these issues at all really about the timing, except to say, this is the hammer that's coming down if you don't get this done by December. I think that was a real problem under the Maine Human Rights Act and the ADA. If it was something that the employer was going to require, then it needed to be clearly stated instead of coming down on my client with this testing trials that was imposed on her. In addition, she was never required to do any other hikes through the summer besides these hikes. If this was so important, then why wouldn't respondent have responded more quickly? The fact is she had, and I provided the job description because it really does go over that this employee is really important to park education, to outreach, to creating media, social media and other media, to creating educational programs. There's a reason that this position has wilderness interns that they supervise, because those are the folks who will go out into the park as well. So if it was that important, it should have been listed. It wasn't, and my client was deemed to be able to do the essential functions until she asked for that accommodation to heal.
Okay, and thank you for that. And I just want to clear up, I'm under the impression that she was terminated because of her injury, right? She gets injured, she can't hike, and she says, I need to be excused from hikes for the foreseeable future. The employer tries to move her to other positions. She refuses those, and then she's terminated. Am I missing something? Is it your position that the timed hikes had something to do with her termination?
It's my position that she asked for accommodation for what they were asking her to do, and they terminated her for it. I think that's disability discrimination. They regarded her as unable to do the job, even though she could. As far as the situation with the other job offers, one was a job offer in a cafeteria at the former Augusta Mental Health Institute in Augusta. The other was a janitorial position, I think, in a school. These were not in line. She is a top wilderness educator. She was in a high-level position in another state prior to coming back to Maine, where she grew up and is from. She invested in a living situation up in Millinocket. So to say that they offered her other options is really meaningless, given that they paid less. They weren't in line with my client's education and experience and her investment that she made to work in Millinocket at Baxter State Park.
So your position is she should have either been offered, a better position or placed on leave or something, right? Not terminated, something along these lines?
She wasn't even asking for leave. She was asking for not having to hike at that point in time. She was happy to keep doing her job. She was loaded with tasks that she was into and doing as interpretive director. She just needed to take a break from hiking. That's all. She would continue her work. She would continue her dedication and everything that she was doing in all of her projects. She simply needed a break from hiking due to her injury. And the park was going to be closing in December anyway. So the fact that the respondent fired her in that manner was really unnecessary. It wouldn't have been an undue hardship for them, even if they could say that this was proper for them to be forcing her to do this series of tests, which is improper under the ADA and the Maine Human Rights Act for them to do. So she wasn't asking for much, just, the park's closing anyway. I'm injured, I just need to heal.
Yeah, I definitely get your point about the timing. All right, thank you so much.
Thank you so much, Commissioner.
Any other commissioner questions for Attorney Aiello? Seeing none, you'll have a little under 2 minutes left when we come back to you.
Thank you.
I'm going to reserve any of your time.
Reserve 3 minutes. Good morning, commissioners, commission staff. My name is Jeremy Carter, Assistant Attorney General, representing Baxter State Park Authority this morning. Just as a matter of background, this is a case where BSP and the Maine Human Resources officers really sought to help Ms. Toms do her job. This is not some punitive rush job that complainant has made it out to be. They worked with her for a full year to try and get her to a point where she could safely and successfully complete the essential functions of her job. Unfortunately, at the end of that year of probationary period, that didn't happen. Now, a couple points to respond to Attorney Aiello that I'd like to raise. There's been a lot of talk about timed hiking and whether or not timed hiking is an essential function. The question is not timed hiking, it's safe hiking. It's made out to sound like these were, Olympic trials in hiking where she was required to sprint up and down the mountain. A lot of these weren't even mountain hikes. That's not the case. They took the average hiking speed for a competent hiker. They slowed it down even further for her and said, please just complete it within this time frame. That's about a matter of safety. For example, if I went out on a hike that took the average safe hiker 2 hours, but it took me 12 hours to finish it, it's not really me hiking safely, because that means you could get caught at night in bad weather and have to have rescue. So again, this emphasis on timed hiking really, as Commissioner Douglas, I think, pointed out, it didn't really even come in to the final determination there because she was meeting the times. They were very generous times. They were very liberal times that she was given to complete the hikes. The problem here is that hiking is an essential function of this job. In the job description that was posted, it says the ability to hike for 2 to 3 days in rugged backcountry. That's a job function. This is Baxter State Park. It's a little idiosyncratic. It's a little bit different than most other jobs you're going to find in the state. But hiking for all employees, or most all employees up there, that's part of the job. And she was informed right from the start that hiking in rugged backcountry terrain was part of the job. So when she started in the winter, so they weren't forcing her to do it then. By the time she hit her about 5-month probationary review, they were saying to her, look, you have to get to Russell or Chimney Pond by the end of the season. Those are some of the highest climbs, and I believe they were on the list as potential stage 3 climbs. They were sort of the highest up, hardest climbs that employees of Baxter State Park are expected, frankly, on day 1 to be able to do. Baxter State Park bent over backwards, went out of its way, even though she couldn't do it on day 1, as the job expectation said, and tried to make a plan. Her doctor said that she would benefit from a gradual increase in hiking. What alternative accommodation might there be than setting some sort of plan to gradually increase her hiking, which is exactly what happened here. Now, to suggest that it was punitive, again, as Commissioner Douglas raised, just doesn't make any sense. This was not some plan that was thrown together overnight or one afternoon. It took a lot of work from the HR manager and her direct supervisor to map this out, figure out the times, pick which trails to use so that she could best advance in her hiking program. It wasn't done with animus. They could have just said, hey, the job requirement is to hike. You're in the probationary period and you can't hike up to Chimney Pond. You can't do that. You failed your probation. That would have been to not accommodate. That would have been to ignore her request. That's not what Baxter State Park did. They said, you're in probation. You should be able to do this. Let's work to get you to be able to do it. And they spent a lot of work and a lot of time doing that. If there was discriminatory animus here or a punitive element, there would have been no reason to do that. It just wouldn't make any sense. And then finally, as to how things concluded, with Ms. Tom's employment, she hadn't completed her probation. As I said, she had to demonstrate that she was proficient in hiking up to 2 to 3 days in the rugged backcountry, including going up to some of the tougher climbs, and she hadn't done that. It wasn't really about the times. The hikes she'd completed in time, but she hadn't finished the hikes. And she came in November and said, I'm not going to be able to do it. Now, Baxter State Park was in a tough position there because we are not allowed to extend an employee's probation to longer than a year. It's not a policy, it's not a preference, it's state civil service rules. So we would have had to say, okay, you've passed your probation. Essentially, that's the only way we could have kept her on in the position when she hadn't. She hadn't met those expected functions. As far back as May or June, she was told, we need you to climb up to Chimney Pond or Russell Pond. That's what's expected for your probation, and she hadn't. So what Ms. Tomes essentially is asking for there is that she be allowed to pass a probationary period that a non-disabled employee would not be, or that we wouldn't pass. It's a kind of a benefit that the Maine Human Rights Act and the ADA doesn't require. It doesn't require the lowering or altering of performance standards to accommodate. The purpose of an accommodation is to help the disabled person get there to the same standards with or without accommodation. And that was the problem there at the end. She couldn't pass her probation. She was offered reassignment. We totally understand why she didn't want those jobs. But reassignment is to jobs that are available in the state for which she was minimally qualified. And at that time, unfortunately, there were a limited number and they were not desirable. So this was a process where every step of the way, HR tried to help, tried everything it could to get Ms. Domes to a place where she could perform her job functions. It was never punitive. It was always responding to what she asked for. And ultimately, she wasn't able to pass that probationary period. She has to be able to hike safely. It's a dangerous environment up there. It's not a sort of a small coastal state park. That's the Maine woods up there. That's the real deal. So she has to be able to get around safely, effectively. These weren't races. To suggest that they're time trials is totally misleading. That here's a casual hiking pace, we'll slow it down. Please just get it done within this time. And at the end of the day, that wasn't even what the problem was. The hikes she had completed, she completed within that time period. So it's an unfortunate situation. We don't deny it. And it's even more unfortunate because Baxter State Park really wanted to work with her, really wanted to make this work. But unfortunately, it was an expectation of anyone who works out on the trails, anyone who works in the park. You've got to be able to hike. You've got to be able to hike safely and effectively. I'd take any commissioner questions if there are any.
Thank you. You said something interesting, and I want to make sure I understood. You said as part of the, I think you said state law, civil service, that you're not allowed to extend a probationary period, or
it's the standard is 6 months.
Yep.
There's a rule in the civil service rules that says you can extend that 6 months up to an additional 6 months. So you can't go over a year.
Okay.
And her year would have been, I think, early January.
Okay, thank you.
The other commissioner questions? Yes, Commissioner Devlin.
Yeah, just to follow up briefly on Commissioner O'Brien's question. So she was hired on January 18, right? You're telling us that according to the civil service rules, her probation had to be completed by January 18, 2023, correct? So am I understanding that right?
Well, she had her 6 month probation had already been extended. At that point, the latest it could be extended to would be January 18th, correct?
Right. So that's sort of the answer to, complainants' comments about the timing. The park was going to close. It was November, et cetera, et cetera. This had to be done by January.
Well, yeah, that was when her probation ended. And as I said before, the expectation of an accommodation is not to give a disabled employee lower standards. It's to allow them to perform at the same standards. And unfortunately, she didn't pass her probation. If a non-disabled employee had been in the same situation, they wouldn't have passed their probation. So yes, that was the problem. The fact that the park was going to close, I mean, there was still time. You can still hike in December. Not all of these hikes are above tree level. They're not all in freezing conditions. People can and do hike in December. That's why, again, as far back as May, she was told you have to be able to get up to Russell or Chimney Pond. This wasn't something that was sprung on her. She was told in May, and this went all the way into November, December. So That was the problem.
All right, thank you.
Attorney Carter, what you just said, that not all the hikes are above tree line and she still could have done it. You're saying that that's your position in the face of a doctor's certificate saying that her disability is such that she needs an accommodation, she can't hike for a while.
Oh, I was just responding to the point that it was too cold to hike, not her particular situation. The suggestion that, oh, well, now it's too cold, so we couldn't finish it anyway, even if there wasn't this other factor.
Why can't you give her more time? You're saying that you're legally prevented from doing that as an accommodation to a disabled person that's injured, that can't possibly fulfill the requirements at that point. Too bad, January, the clock ticks and she's out.
I think this is a very unique situation that wouldn't come up very often.
Right.
I also don't think the record suggests that this injury that she had was necessarily a disability. They haven't pressed it as one. They haven't suggested it. Investigator Brindley raised the same point. It was an injury. We don't know what the extent of it was. She didn't share that. She just said, I can't hike anymore. But even if it was.
The doctor said she can't hike anymore.
Right. Even if it was.
Not sure.
Correct. The doctor did. But even then, there's still a question of whether or not she can pass her probation. And she didn't. And we are not allowed to extend it beyond a year.
You said at the beginning that the requirements require being able to go 2 to 3 days in backcountry. And am I looking at the job description that was attached?
I think that's the one Ms. Aiello attached, which I wouldn't imagine had that language, but
is the language you're referring to in the record?
yes, it is. We submitted it at, well, I can find it for you specifically. Let me find my close of evidence submission.
Because it's not in this description.
But I can say, no, I'm not surprised by that.
Attorney Carter, that's a little snide. I mean, it says Baxter State Park.
Well, no, that one's in the record too, and that one has been previously cited to. I'm just saying that
Okay.
the one that says 2 to 3 days is attachment 2 to our original submission.
Other commissioner questions for Attorney Carter? And,
Thank you.
Attorney Aiello, you have 1 minute and 51 seconds. You're muted.
Oh, sorry. I'm stunned at the suggestion that the ADA and the Maine Human Rights Act are basically trumped by a probationary period that has to occur. The purpose of the ADA and the Maine Human Rights Act is to ensure that people with disabilities have equal opportunity. To say that she's cut off, that's it, we can't consider any requests at this point because of a probationary period, which they already altered, is stunning to me, and I think lacks merit. The fact is they chose to terminate her when she asked for an accommodation. They said they treated it as an accommodation, and now I'm hearing that they're denying that it was a disability. So it's a moving target. The job description that I provided was straight from Baxter. It was the most complete one that I could find. There's no evidence that my client was unable to hike for 2 to 3 days in the backcountry. My client was a qualified individual with a disability. She was terminated because she was regarded as unable to do the job. And there are reasonable grounds to believe that discrimination and retaliation occurred. Thank you.
Commissioner David.
Attorney Aiello, remind me, I understand the first argument about the disability. Remind me why you say that it's a retaliation.
Well, Commissioner, there was retaliation that occurred because when you look at the standard for retaliation, prima facie case is engaged in a protected action. Requesting a reasonable accommodation is a protected action under the Maine Human Rights Act. Suffers an adverse action, which here was termination in the second instance. And in the first instance, she was given a series of timed hikes that she had to complete, or she would be terminated. And And then third, a causal connection between them. So here, my client, when she engaged in the protected activity of making the accommodation, that's when the adverse action occurred. And that's why we say that that retaliation occurred in this case.
Thank you.
Thank you.
Brian?
Thank you. I'm gonna ask that same question. Your retort was that clearly, well, I don't remember the word you said, but you were astounded, or the words to those effect. So are you suggesting or stating that that is not a truism? That the civil service rules, state law does not prevent that?
I think the cornerstone of the Americans with Disabilities Act is the ability to provide accommodation to people with disabilities. And that occurs sometimes when an employer might say, there's another law that we're trying to comply with here. First of all, it was never raised to this point about civil service and probate having to happen within the year of probation. I don't recall that ever really being raised through the commission process, except vaguely. And now it seems to be a central point, but I think that it is a problem, and I am stunned to think that an employer would say, we can't consider accommodation given the circumstances of the request.
Commissioner Sanders?
Yeah, I just, I want to understand that better, Attorney ILO. I think I just heard you say that this point that the state is now making, I think what you said was has not been raised prior to today, except vaguely. Can you just say more about the context in which it may have been raised prior to today, or not?
I will say that they said several times that she hadn't completed the hikes during the period of probation. That's what I heard. I don't know where that standard is coming from. Like they're equating that with not meeting the terms of her probation, which I disagree with, because the timed hikes, the way they set them up, are not an essential function of the job. And so I really didn't understand where they were coming from when they were talking about probation sort of being the tail wagging the dog here. We must get this done in time for probation. But our position is she was meeting the essential functions of the job. She was doing the hiking. So suddenly their timed hikings and series of hikes becomes an essential function of the job, and she's deemed unable to do the essential functions of the job at that point. There's no credibility to that argument at all. She was doing the job. She was completing the hikes. When she got injured, she asked for an accommodation. So I'm not clear on how suddenly their series of hikes that they raise and they say that she must meet when in response to her request for accommodation, how does that suddenly become an essential job function? It wasn't. She did meet the terms of her probation. They extended it. And actually, I think it was Commissioner David's point, they terminated her like 4 days after she made the request. And the probationary period, apparently, they're saying now ended in January.
Good morning.
So none of it.
Grace Nichols at the Maine Human Rights Commission.
Grace, sorry.
Hey, Mr. Kerrigan.
Grace, sorry, Kristen, go ahead. One of our investigators who's watching the meeting by Zoom, but is also at her cubicle doing work and forgot that she was unmuted.
It happens. Commissioner Sanders, I hope that I answered your question. I don't think my point is, I don't think that it makes sense. It holds any water to say she didn't meet probation when they gave a standard later saying that she needs to do X, Y, and Z hikes in this amount of time tracked by GPS. And if she doesn't do it by the end of probation, she doesn't meet her probation. I don't think it's not an essential function of the job. She was hiking. She was moving in backcountry. She just got injured and she needed some additional time to heal.
Yeah, and so with respect to my question, I'm very curious about this issue that Attorney Carter injected here today, which is, how the civil service rules apply. Perhaps it's something that Investigator Brindley could shed some light on, right, to the extent that that issue has been asserted here. And if it has, we could get some guidance from the investigator about, is it relevant? Is it not relevant? How might that help guide the analysis? So I can certainly ask any relevant follow-up questions to Investigator Brindley.
I would appreciate that because I'm 99% sure it's not in the investigator's report, and I didn't see it in and I didn't hear it raised in that regard about civil service rules until now.
Okay. Any further commissioner questions for Attorney Aiello?
Thank you very much.
Seeing none, Attorney Carter, you have 3 minutes.
Well, I can clear this up very quickly where this sort of civil service argument comes from. I'm not injecting it today. It was in our close of evidence response at about 2 pages in length. Investigator Brindley asked, after complainant's injury in October, why did respondent decide not to postpone the hiking plan until the next season? I then go on for about 1.5 pages, 2 pages to explain the civil service rules. So frankly, I'm a little stunned that it's now being suggested I've just raised this today. It's in the record. I understand Investigator Brindley did not mention that in the report. That is true, or at least delve into that issue. I concede that, but we certainly raised it and we have certainly discussed it. We cite the EEOC guidance. Again, Attorney Aiello says she is stunned, but these rules are clear. The EEOC guidance says, may an employer apply the same quantitative or qualitative requirements for performance of essential functions to an employee with a disability that it applies to an employee without disabilities? The answer, yes. An employee with a disability must meet the same standards, whether quantitative or qualitative, as a non-disabled employee in the same job. Lowering or changing standards because an employee cannot meet them to a disability is not considered a reasonable accommodation. So again, this is not a new argument. We submitted it February 18th at the close of evidence stage. It's been in the record the entire time. I'll just wrap with this. There was an expectation that she should have been able to do all of these hikes when she took the job, the day she started the job. We worked with her when it was discovered that she couldn't. To suggest that we changed the ball or hit anything is not true. She was told as early as May there was going to be an expectation that she'd be able to do the hikes to some of the highest campgrounds, Chimney Pond, Russell Pond. She didn't do that. She couldn't pass her probation because every employee who would have been in that position or similar ones would have been required to complete those same things. For most employees, I imagine it probably wouldn't have been a question. They would have just done it. In this situation, there was some difficulty, and we worked very hard to accommodate that. It didn't work out, unfortunately.
Any commissioner questions for Attorney Carter? Seeing none.
Thank you.
We've heard from the parties, and next we will hear from Alex Brindley, the investigator assigned to this case.
Hi, good morning, commissioners, everyone. I took some notes while I was sat here, and I'm just going to run through some of the concerns that seem to have been brought up in regards to this case. First, I want to go to the reasonable accommodation analysis. So it was brought up here and during the investigation, the idea that the timed hiking wasn't reasonable. However, when I was doing this investigation, when I conducted the Issues and Resolutions Conference, what I found most compelling was the testimony from complainant's direct supervisor who was out there in the field with her on the mountain. That supervisor in question really highlighted the effect of safety and efficiency in order to complete these hikes. In order for Ms. Tomes to be able to perform the essential functions of her position as an interpretive specialist at Baxter State Park, she did need to be able to hike. Number one, needed to be able to hike safely so that she does not, say, take an excessive amount of time on the hike, maybe get lost at night, because, you know, hikes in the wilderness can be dangerous. And also effectively. Second, she needed to be able to, after she performed this hike, perform her job duties once she reached the location, whether it be to update signage or to provide training or information to guests on the mountain. Now, let's see. I think that was most telling for me in regards to the reasonable accommodation request, although my analysis is quite extensive in that regard. So, and then I think the other thing that was just brought up is the issue that we could not, or rather the state of Maine could not extend probation past that initial year. I didn't really address that in my report because I didn't think it was necessary. If you look to my analysis on page 8, complainant established a prima facie case. She has a disability. She performed her job satisfactorily, at least it stated so in her review, and then she was discharged from employment. However, respondent provided that she could not perform the essential functions of her position with or without a reasonable accommodation. As highlighted below, the reasonable accommodation of the gradual increase of hiking was implemented through this hiking plan to ensure that complainant could safely and effectively hike in order to perform the essential functions of her job. When she provided a doctor's note in November stating that she could not hike for, let's see, she wrote it down for the foreseeable future. That was essentially the indication that she could not complete her probation. She couldn't complete the hiking plan as required and could not complete her probation. But let's see. I think that might be everything that I wanted to address at the outset, but I'm, as always, open to any questions.
Commissioner, questions for Investigator Brindley? And I'm going to put Barbara on the spot here. Any commissioner questions for council? Because I know there were a couple of things that came up that might be more appropriate.
Yes.
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 Brian.
The question, the civil service rules or law, how does that affect it?
Well, the civil service rules do provide for an initial 6-month probation with an extension for up to another 6 months, but that's as long as it can be. What I will say is that as a general rule, we do not require employers to break the law in order to grant a reasonable accommodation. You have to make the decision within the year. And at that point, they felt they were reaching the end, that there wasn't going to be any more hiking in the park. So they had to make a determination based on the information that they had.
Thank you.
Okay, so we have heard from the parties and the investigator and our legal counsel. At this time, we'd be looking for a motion. There are 2 proposed findings.
To push this off as long as we can.
I'm in the same boat. I don't know.
Yeah, I can't find that. Yes. Yeah.
I don't mind.
But I'd like to take them separately.
All right, we take these separately. The first is I would move that there are no reasonable grounds to believe that the state of Maine and Baxter State Park discriminated against Crystal Tones. That would be number 1. I would move.
Do I have a?
On the second.
All right, Commissioner O'Brien, is that a second?
Unless you're not done.
No, we were gonna split, Ed had asked to split.
Oh, okay.
Yeah.
I second that.
Okay, so moved and seconded on the first recommended finding. No reasonable grounds to believe that the respondent discriminated against complainant on the basis of disability. Moved and seconded, any discussion? Commissioner Gibbon.
Yeah, I'm persuaded by Attorney Aiello's arguments. I think she had a disability. She was trying to complete the hike. She came up against a physical injury. Without the physical injury, I would vote that there are no reasonable grounds. But she had an injury. They could have accommodated that. I don't believe that the civil service requirement would have prevented that.
Did I not just hear Commission Counsel tell us that, you know, that we don't require employers to break the law in order to provide a reasonable accommodation? I guess I'm a little where I'm struggling is, you know, at this point we're almost a year out, right? When she reports her injury, they offer a couple other positions. I guess there aren't a ton of positions available, as I understand it, and that, you know, she doesn't want those positions. She can't do the hike. She can't complete the timed hikes within a year. She can't hike at all for a while. I mean, I just don't. How do they then accommodate her? Like, what is the fix if they can't go past the year?
Further time.
Sorry, I just wanted to interject and further explain. It wouldn't necessarily require them to violate the law. What it would require was for them to pass her on probation and she would become a permanent employee, which comes with all sorts of different rights.
Oh,
So
I
that's
see.
the decision they were facing.
So they could have made her a permanent employee, notwithstanding the fact she had not completed these hikes, even though she had made all the timed hikes, right? She had made them all. At least that's my understanding, although there's some conflicting evidence in the report here. Okay, all right. Well, now I'm gonna need to take a walk and think about this.
Sorry, I realized that I was conflating a couple things when I was talking. Both things I said are true, but in this case, I think that the choice that they were facing was making her a permanent employee with all the rights and benefits that come along with that, without knowing if she could hike, complete the hiking requirements, or letting her go.
I always consider everything Commission Counsel says by definition to be true, by the way.
As everyone should.
Any further, yes.
I guess I would look at it as you can't extend the employee's probation period based on the state civil service laws, but you could say that the employee met her probation requirements, you know, almost, to me, one or the other. She did complete several hikes. I mean, maybe that could have been interpreted as being satisfactory. You can't extend probation beyond this period.
Correct.
So therefore, your option is to say that she met her probationary requirements.
She is trying, and then she gets injured, and the park closes.
I don't know who I'm throwing this out.
I'm sorry, I've made this much more.
Yeah, I think
confusing than it was when you started.
Well, wouldn't it, again, I don't know who I'm asking this of, but wouldn't it, if they did make her a permanent employee, wouldn't that have raised the standard for disability, for a disabled person as opposed to a not? I mean, I'm not making myself clear, but I know what I'm saying. No, you don't get me, you don't answer. Do you know? Correct. Done.
Sorry, I don't know. Are you asking if it would be a lower standard?
Yeah.
Again, they just had to, they made the call as to whether she had done enough to pass probation. I don't.
Okay.
Could they have made a different call? would it have been a reasonable accommodation to do so? I think that's what you're wrestling with, and I think it's the right issue. I think you're wrestling with what you're supposed to be wrestling with. I just can't give you the answer. You talk.
Okay. Any further discussion? Seeing none, the motion is to find no reasonable grounds on the first recommended finding. If you are in agreement, you'll vote yes. Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
No.
Commissioner Sanders?
Yes.
Okay,
Mm.
so that motion passes. We need a motion for the second recommended finding. Yes, Commissioner Walker.
I would move that there are no reasonable grounds to believe that State of Maine Baxter State Park Authority retaliated against Crystal Tones for engaging in protected activity, and that the claim should be dismissed.
Second. That's what I want.
All right. So moved and seconded. Any discussion? Okay. Seeing none, the motion is to find no reasonable grounds on the second recommended finding. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds on both counts. Appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing. I think we should take another 5-minute break so
Okay.
that the commissioners can decide what they would like for lunch and then come back.
Okay,
Ready?
You there, Megan? Okay, we'll call the meeting to order. The next case for hearing is Levesque versus Brown Aroostook Animal Hospital, E230159 A and B. The recommendation is for a finding of no reasonable grounds on both counts, and therefore we'll hear from the complainant.
Is there anybody here for June Levesque? Nope, because I ordered lunch, so now we're gonna get out early.
I figured that was gonna happen.
Sorry, we've got plenty to talk about in executive session. All right. One more call. Anybody here for the complainant in June Levesque versus Brown and Aroostook Animal Hospital? Seeing none, does somebody want to make a motion?
Sure, I'll move that we find that there's no reasonable grounds to believe that a respondent unlawfully discriminated against a petitioner, and the charge should be dismissed. Second.
Moved and seconded. Any discussion? All right, seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Findings are no reasonable grounds. Attorney Ware, thank you for being here. And we will send a letter to the parties in the council confirming the results of the hearing. I know.
The next case is Green versus Lee Auto Mall, E230202. The recommendation of the investigator is for finding of no reasonable grounds on both counts, and therefore we'll hear from petitioner, from plaintiff.
One note before we dive in, I need to recuse myself from hearing this matter, so I will not participate and put myself off camera.
Thanks, Commissioner. Attorney Morris, do you want to save any of your time?
No need to formally do so. Thank you.
Whenever you're ready, go ahead.
Thank you. Good morning. We're still morning, I guess. Good morning. My name is Sally Morris. I represent the complainant, Richard Green, in this matter. The complainant worked for the respondent company from 2008 until July of 2022. I know you have all the materials in front of you, so I will be brief. At the heart of our objection to the report and findings in this case is that we believe that the respondent did not overcome the presumption that is allowed by the timing of discipline after my client made his complaint. There is no real dispute that there was protected activity here. The complainant reported that a coworker was fraudulently affixing customer names to financing paperwork. And that's unquestionably protected activity. I don't think anybody really disputed that. And the timeline is that my client made that report in December of 21, and then was disciplined in January of 2022. So just about a month later, he complains that he was spoken to repeatedly after that. That was after receiving a performance award in 2021, and that in July of 2022, as he continued to sort of express his complaints, which we submitted in the exhibits, he was told that he was going to be fired if his performance didn't change. My client took that as his job was over, and left the employment at that time. We allege because that all of these events occurred because he engaged in the protected activity.
Okay.
Thank you.
Any more questions for Attorney Morris? Commissioner Douglas?
Yes, Attorney Morris, good morning.
Good morning. Good to see you.
Good to see you. I just wanted to get your take. I'm looking at the investigator's report. I understand your position with respect to the causal connection, all that, the time frame. You know, what the investigator found was that, and I'm just quoting, complainant failed to show that he would not have received criticisms about his performance or been issued a written reprimand, but for his report to manager. It seems that the investigator relied on some alleged performance issues on the part of your client. And I guess my question for you is, are you saying that there were no performance issues? Like there's no merit to that, or yeah, what's your take?
No, I see what you're saying. And I guess the response to that is my client had worked at that company since 2008. And in his mind was performing his job as he had always performed it. You also see some reference in the documents to the fact that they knew he had some health issues and they were giving him some latitude for those health issues. And so, no, in his mind, there weren't performance issues. He was performing his job. They were aware of the health issues. They were giving him the latitude, and that changed when he made the report.
Okay. All right. Thank you.
Any other commissioner questions for Attorney Morris? Seeing none, you have about 8 minutes when we come back to you. Attorney Haley, do you want to reserve any of your time?
Not officially. I'll just use the time and then respond as necessary. Thank you. Good morning. Thank you for having me. My name is Brooke Haley. I'm here on behalf of respondent Lee Auto Malls. I think it's important to point out that this is a constructive discharge case. The complainant did resign in July 2022. The Lee Auto Malls at the time of his resignation asked him whether he was sure, asked him whether he would prefer to work in a lower volume dealership to better achieve his goals and his performance expectations, and he declined. And that was the second chance that Lee Auto Malls offered him to work in a lower volume dealership to be able to better perform his job duties. So the complainant needs to be able to prove that his work environment was so severe or pervasive that it created an abusive working environment that no reasonable person would be able to work in. And criticisms of performance are not adverse employment actions, and the criticisms of his employment are supported by the record. As Attorney Morris mentioned, the timeline is important here. In April and in July 2021, there were two new sales managers brought into that dealership location who reviewed Mr. Green's performance with a new eye. It was noted that he was taking longer than expected to complete deals. He needed to pay closer attention to details, and he lacked follow through on contracts in transition for funding. This is consistent with performance evaluations that he had received years earlier. In August 2021, one of the new sales manager began tracking Mr. Green's contract and transit issues that required follow through, and continued to track those issues from August 2021 through February 2022, when it became too time consuming to maintain. We have produced a October 2021 photo of Mr. Green sleeping in his car when he was expected to be on the clock. We have produced text messages from November and December of 2021 in which Mr. Green's manager was consistently looking for him, letting him know that there was work on his desk to be completed that has not been completed. We do concede that Mr. Green made a single report verbally in November 2021 that he believed that a coworker, another F&I manager, had forged a single customer's signature on a single piece of paperwork that was associated with a vehicle transaction. That allegation was investigated, and it was unable to be substantiated. That allegation was the same, was brought up again in December 2021 when Mr. Green provided a transaction number to his direct supervisor, that was the transaction that he believed his coworker had committed fraud on. And again, it was unsubstantiated. In January of 2022, Mr. Green's supervisor sent an email with well-documented complaints from upper management, from sales managers, from the sales team. He had spoken to Mr. Green's wife twice in that time frame about not being able to locate him at work. There was a significant lack of communication regarding attendance and absences, and it refers back to 4 to 6 months of issues with Mr. Green's performance, reliability, and attendance. A number of times to fail to follow call-out procedures. Again, a number of text messages asking where he was. And when his supervisor met with him in January 2022, Mr. Green acknowledged that he had no excuse, that he would take responsibility, and that he would do better in the future. But unfortunately, his performance did not improve. And in June 2022, his supervisor met with him again for a formal performance counseling review, highlighted a lack of follow-through on several issues that were discussed with complainant in January 2022, including the same issues with a lack of follow-through on contract and transit issues and complaints from customers and employees. And then Mr. Green resigned approximately a month later and let Lee Otto Malls know that he had been offered an opportunity, a better paying opportunity elsewhere. And again, as I stated previously, Lee offered him the opportunity to transfer to a lower volume dealership at that time. And that was the second time they offered that opportunity, and Mr. Green declined.
Commissioner, questions for Attorney Haley? Commissioner Douglas.
Yes, Attorney Haley, good morning.
Good morning.
So I thought I heard you say that there were some performance issues from before. I think your words were from years prior.
Yes, Mr. Green, I'm sorry, Attorney Douglas, were you done with your question?
I was, yes.
Okay, great. Just wanted to make sure I wasn't cutting you off. Yes, there were performance issues brought up, I believe, in 2014. And again, in the interim, just about the lack of follow through and needing better attention to detail. So that was a theme that kind of runs through Mr. Green's performance. But he did receive 2 new supervisors in mid-2021, where those issues were kind of brought to light.
Right. Well, I mean, I appreciate your detailed presentation. I obviously, we can all see what the direction you're going. I guess I'm just wondering, I mean, complainants counsel says he made these complaints, he blew the whistle, so to speak, and then very close in time, there's a change, right? You say he's had these performance issues for all these years, and then all of a sudden it seems like at trial there could be a finding that he had the issues, they sort of let him slide, he gets the positive performance review in January of that year, and then he raises these issues, and then all of a sudden things change. And I guess what I'm wondering, I'd like you to respond to, is why is this not sort of more of an even chance kind of a case? Like what puts it beyond the realm of like an even chance sort of analysis in your view?
Because there has been no retaliation whatsoever, and there was no adverse employment action. A critique of a performance is not an adverse employment action. In order to say that his constructive discharge, was an adverse employment action, Mr. Green would have to prove that the time period between his quote unquote whistleblowing and his constructive discharge was so hostile, severe, and pervasive that no reasonable person would have been able to work under those circumstances. He received, performance counseling that's just typical with any sort of employment relationship. Of course, there is a window cleaner.
Sorry, I started laughing. I'm sorry to interrupt you. There were legs.
So, but I'm sitting here for hours without that. But yes, I guess
you staged it that way. I know.
Yes. If he was wearing a Spider-Man mask, that would have been. It's just typical employment counseling. He was not threatened to be fired. He was given an opportunity to work in a lower volume dealership, and he declined. His allegations were investigated. They were unsubstantiated, and that was kind of the end of the story. And when allegations, it was reported back to him, Mr. Green never complained that he was being retaliated against. When he had discussions about his performance, he acknowledged that he hadn't been doing well, that he had no excuse, and that he would do better, and did not say at any time that I think you're only bringing these criticisms forward because I, quote unquote, as you said, Attorney Douglas blew the whistle.
Okay. I mean, isn't a lower volume dealership, doesn't that translate to less money?
I don't know all the terms of Mr. Green's employment, to know how that would have affected him. But, you know, even after he gave his resignation, people who had nothing to do with disciplining him said, you know, we'd love to keep you. Are you sure that we can find another spot for you? And he declined the opportunity and said that his subsequent opportunity was a better paying opportunity.
All right, thank you. I reserve the right to ask more questions if I see another Slenderman type figure outside.
Yes. I think he's moved on, but thank you.
Thank you.
Any other commissioner questions for Attorney Haley? Seeing none, we'll go back to Attorney Morris. You have 8 minutes.
Thank you. But sort of searching through my materials here, the respondent is referring to unsubstantiated allegations, but I believe in the papers after my client was done at the company, the allegations were substantiated. The fraudulent signatures did in fact happen. And I'm sorry, I wanted to provide you with a citation and materials, but I can't find it quickly. And then the only other thing I'll say is that I think what's relevant here is the contrast between the way my client was doing his job for such a long period of time, acceptably to the company, to Commissioner Douglas's point that he may have been in 2014 and 2016. He may have been called out for some stuff, but he didn't lose his job. It was acceptable to the company. And then when he makes these reports, suddenly things change. And I think the context of the long period of time that he was working there, and then the reprimand specifically says he will be terminated. So that's how he took it. And he felt like he had no more choice, that his job there was done and that he was effectively discharged. Thank you.
What you were looking for is that it's February of 2023, months after his resignation, that they find that the coworker did forge a document and the coworker was fired. So how does it bear on your argument?
Well, because what my client was reporting was not unsubstantiated. If it was unsubstantiated.
Okay, and don't you have to show that they're in the months that after he reports it, that the employment is intolerable because they're
Sorry, I froze for a bit.
Don't you have to show that they're retaliating against him for the report for those months up until he resigns? Are you hearing me?
I'm sorry, just like Spider-Man in the window, my internet is now choosing this time of the day to act up. So I froze.
I'm just asking you, don't you have to show that the employer retaliated against him for making the report in order to get to a constructive discharge?
Yes.
That they made the employment intolerable. What evidence is there of that? That you were saying they trumped up these complaints about being late and not being able to be found and not doing work?
I guess what I'm saying is that my client was doing his job the way he had always done it, and it was not a problem for 14 years. And then when he makes a report, it suddenly was a problem.
I hear you about that, and I often am impressed by the length of prior employment before we get to the Human Rights Commission, but it's a two-edged sword. It's also that after that kind of longevity, felt that he didn't have to show up on time, and that he could go shopping and take long lunch hours. But the complaints were being made, and the the investigator finds that he acknowledged that. How do you account for that? That he acknowledged the complaint, said he'd do better.
Well, I mean, I think that those complaints came up after he made the report. I think that's he had some discipline in 14 and 16. Then fast forward to 21 and 22. In 21, he makes the report, and then his performance starts to be criticized when he says, I promise I'll do better.
Thank you.
Any other commissioner questions for Attorney Morris? Seeing none. Attorney Haley, you have 5 minutes and 14 seconds if there's anything else you'd like to add.
Great, thank you. I just wanted to point out that the complaints were not by the person that that he reported this quote unquote whistleblowing to. There were customer complaints, there were coworker complaints, there were complaints from upper management, there were complaints from supervisors that were not responsible for investigating the quote unquote whistleblower allegations. And at the time that he made those allegations, they were unsubstantiated. When an independent event gave more information to Leota Malls in February 2023, that we were able to substantiate that there was some fraudulent signatures, that employee was let go immediately. And so there was no retaliation against anyone who raised any concerns. Leota Malls would absolutely want to know if any of its employees were engaging in any sort of fraudulent conduct, and would take remedial action promptly, as it had. There's just no evidence here that there were any retaliation. Mr. Green admitted that he had no excuse for his performance, and he was not terminated. When he had that formal performance evaluation in June, it was discussing nearly a year of problematic performance. And it was Mr. Green's decision to resign and not Leota Malls.
Questions for Attorney Haley? Seeing none, thank you both. We will next hear from Alex Brindley, the investigator assigned to this case.
Hello again. I just very quickly want to state just something. So I want to note first that this complaint was filed on exactly the 300th day from the date his employment ended, meaning as per footnote 2, that any allegations can only be considered timely if he can establish that his resignation was a constructive discharge. In order to prove a constructive discharge, you have to, it says, quote, no reasonable alternative to resignation because of intolerable working conditions caused by unlawful discrimination. In here, based on what I read and reviewed in this case, complainant provided no evidence that he was subjected to an intolerable working conditions because of his report. In fact, criticisms of his performance I don't believe could be considered a hostile work environment in this case. But I'm open to any questions.
Alex, I don't quite understand what the 300 days has to do with it. Is it that he can't show? Yes.
So the 300 day should if
the evidence has to be before the 300 days, or
it has to be within 300 days of the date of filing. That 300th day, if he had filed one day afterwards, it would have been untimely. Which is why only the discharge claim here is timely. Anything before that would not. Which is why the crux of this case is really the constructive discharge because of hostile work environment, because of retaliation claim.
was he trying to make some claim for discrimination before the discharge?
No, I just wanted to make note that he filed the very last day he could in order to make this claim here, and only could show constructive discharge, which he failed to do.
Okay, thank you.
Any other commissioner questions for the investigator? None. Thank you, Alex. We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding. Commissioner David.
I move that we find that there's no reasonable grounds to believe that respondent retaliated against complainant for engaging in WPA protected activity, and the complaint should be dismissed.
Good. All right, moved and seconded. Any discussions?
Yeah, I'll just say that I think the key point for me was that, you know, he's engaging in this conduct at work. He's not doing what he's supposed to do, sleeping in his car and all this kind of thing. And, you know, when he's confronted with it, he sort of acknowledges the conduct and says, yeah, that was me, right? I appreciate the arguments advanced by Attorney Morris, but I just don't think I can get there. So I'm gonna go with the motion.
Discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Sanders accused. The findings are no reasonable grounds, and we will send a letter to the parties and council confirming the results of the hearing.
Closing in on the list of hearing cases, 823-0205, Lauren Harper versus Gateway Community Service. And I need to find my notes. The recommendation is for a finding of no reasonable grounds on both counts. And therefore we would hear from petition.
Still morning, just barely. Good morning, Ms. Harper. You have 10 minutes. Do you want to reserve any of your time? You're muted.
Hi. Hi, commissioners. I'm Lauren Harper. Reserve any of my time? Sure, 5 minutes.
Okay.
Or whatever's left over.
I'll let you know when you hit 5 minutes, okay?
Okay, thank you.
All right, go ahead whenever you're ready.
Hi, I just wanted to respectfully disagree on the investigator findings in my complaint and discuss reconsideration with my submission on the findings of discrimination and retaliation that I went through with Gateway. I've submitted facts in my submission of rebuttal, and the mistakes that I saw in the fact finding or the report. So the date for September 23rd, when they offered me the job, was September 2022, when I was still working as a case manager, when they offered me the job, and then rescinded the job within 8 days after I filed that I was going for treatment at Mass General. Sorry, I have to read this. My company, Gateway, also retaliated against me when I filed a workers' compensation claim when I became severely re-injured with a pulmonary injury that also occurred in also in relation to this. So, but they failed to report my work injury for over 1.5 years, almost 2 years. And then I did report it, and I filed it, but since then that had been closed out. And I know that in the investigator report, Investigator Brindley said that that wasn't going to be assessed. And I had let the submission know that that was all closed out in October and continued to be denied. I'll hold there to see if there's any questions or anything that I can help put together for you.
So we'll end your presentation there, and we'll see if the commissioners have any questions, and then we'll go back to respondent, and then we'll come back to you. So any commissioner questions for Ms. Harper? Yes, Commissioner David.
Ms. Farber, what accommodation did you ask for that they did not provide?
Oh,
Based on your disability?
yes, I had leaves. I was not supposed to be working while in treatment for my treatments at Mass General. So when I requested those leaves, they were not accommodated. And then I also requested a laptop stand specifically, which I never got. That was not accommodated for my arms. And they had ignored. Oh,
I
sorry.
don't understand why you took a family leave, right?
Originally, the FMLA, because they said that that's all I could, as far as my benefits at the company, they said that I couldn't get any workers' comp. I wouldn't qualify for anything else besides FMLA.
Any other commissioner questions for Ms. Harper? Commissioner Brad?
Just very briefly, are you saying you did not get a laptop stand? Because in here it says you did get a laptop.
I did not get a laptop stand at all.
Okay, thank you.
You're welcome.
Any other commissioner questions for Ms. Harper? Seeing none, you'll have about 7 minutes and 40 seconds to come back to you. Attorney Ware, welcome back. You have 10 minutes. Do you want to reserve any of your time?
Unofficially, whenever I've left.
Okay, whenever you're ready, go ahead.
Good afternoon, commissioners. Bill Ware on behalf of Gateway Community Services. The commission should adopt the investigator's well-reasoned conclusions of no reasonable grounds to believe complainant was discriminated against based on a disability or retaliated against. As was the case during the investigation, complainant has offered a plethora of various documents and disjointed allegations, many of which are contradicted by her own prior submissions, including her own text messages. Complainant's kitchen sink approach does not alter the simple fact that her two asserted legal theories are dispositively deficient in multiple ways, as explained in the report. In regard to the disability discrimination claim, the vast majority of her claim was plainly time barred. Indeed, outside of the allegation concerning the alleged events surrounding the possibility of applying for a supervisor position in the fall of 2022, shortly after resigning her employment, the complainant identified no timely adverse employment action. Putting that aside, the submitted evidence showed that complainant was granted FMLA leave when requested and was granted a laptop stand, as was part of our exhibits in our position statement. It should also be noted that that request was not made as part of any reasonable accommodation request. It was just a request for a laptop stand, and it was granted. Similarly, as noted in the report, complainant's claim of retaliation tied to the job posting removal is not credible. As noted in the report, complainant voluntarily resigned her employment. She gave the resignation notice on August 30th, 2022, gave 30 days notice. In her resignation email, complainant noted that it had been a pleasure working for Gateway and thanked her supervisor for everything. Around that time, Gateway's former COO shared that there may be a supervisor position opening soon, and that it was her understanding that complainant might be interested in this position and alerted complainant to that fact. However, the posting was subsequently removed because Gateway found that the applicable department's revenue and billable hours were not sufficient to fund a full-time position. Gateway communicated this to complainant. In a response, complainant responded that the action was understandable. Months later, the position was posted again, however, this time as a part-time position given the related financial circumstances. Outside of conjecture, complainant has offered no rationale or evidence that the withdrawal of this posting had anything to do with her, because it simply did not. For these reasons and the reasons stated in the report, we ask that you adopt the investigator's report and her conclusions.
Commissioner, questions for Attorney Ware? We'll have about 7 minutes left when we come back to you. Ms. Harper, you have 7 minutes and 42 seconds. If there's anything else you'd like to add.
Hi, yes. The supervisor job was offered to me by my supervisors, by both of them, in October when I was still working there full time. I continued to work through because they offered me the supervisor job. And then I submitted that I was going back out on leave for treatment for my condition in Boston. And 8 days later, they took the supervisor job posting down while I was still working there. And then I was going out on a 3-month medical leave.
Questions for Ms. Harper? None? Attorney Ware, you have 7 minutes and 6 seconds. If there's anything you'd like to add?
Nothing more. I believe the record and the report speaks for itself, and I'd ask the commission just to look at that for what it is. Thank you.
Any additional questions for Attorney Ware? None. We will next hear from Alex Brindley, the investigator assigned to this case.
Hi, commissioners. Last time you're going to hear from me today, unless I miss something drastic. Very quickly, in regards to the analysis that was provided here, the two in regards to the reasonable accommodation and the workers' compensation, I'm going to quickly go through those. So in regards to the laptop stand, there is an email that respondent provided stating that it was granted. Whether or not Ms. Harper received it is not in the record. However, as Attorney Ware provided, it was not made as a reasonable accommodation request. She didn't provide it was necessary for any disability. It was simply that, just a request to have a laptop stand. And the other requests for reasonable accommodation for leave were untimely. And then for the workers' compensation claim, we don't have jurisdiction over that unless it's a workers' comp claim that you made with a previous employer. So just quickly jump over that. And then lastly, for the case of retaliation here, Ms. Harper had already resigned from the position. Her supervisors inquired whether she had any interest in the supervisory position. Unfortunately, the position was removed due to lack of funding. And that's all I have to say in that regard, but I am open to questions.
Questions for the investigator? Seeing none, thank you, Alex.
Thank you.
We've heard from the parties and the investigator. At this time, we are looking for a motion. There are two proposed findings.
I would move, and I propose we take these together, and that I would move there are no reasonable grounds to believe that Gateway discriminated against complainant on the basis of disability, and that there are no reasonable grounds to believe that Gateway retaliated against complainant for engaging in protected activity, and therefore complaint should be dismissed.
Second.
Moved and seconded. Any discussion? None. The motion is to find no reasonable grounds on both counts. If you're in agreement, you will vote yes. Commissioner Davis.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and council confirming the results of the hearing.
And the last case for hearing on today's agenda is E 230218. Donna Greasier versus Town of Machias. And the recommendation is for finding of no reasonable grounds, and therefore we'd hear from complainant.
Ms. Greiser, am I pronouncing your name correctly?
Yes, you are.
Okay, great.
Hi, I do apologize.
That's all right.
Yes.
Great. You have 10 minutes. Do you want to reserve any of your time?
Yes, please. If I could reserve at least 3 minutes.
Sure. I'll let you know when you hit 7 minutes, okay?
Okay, then thank you.
All right, whenever you're ready.
My purpose here today is to appeal the decision with your investigator. On November 22nd, I just would like to point out that an employee started with the Machias transfer station. I was employed there as a director at the time. When the employee started, he had some pretty bad behavior. He was always sexually suggestive. He was always lewd. And this was brought to my town manager's attention immediately. I wanted him to address it. It wasn't addressed, as you'll see in my former complaint. It was not addressed. This went on for a month. And this escalated from lewd behavior, conversations. At one time, there was almost an altercation between him and another employee of mine. And it was definitely out of hand. At one point, I was training him. And I mean, just to show this is how early his behavior began. I was training him at this point. I was eating a banana in my office, and he made sexual innuendo immediately. And I brought it to my town manager's attention. He told me that he'd bring him in for a chat. The town manager continually told me, I'll bring him in for a chat. Nothing ever happened. And I looked at the report from the investigator there, and her findings were, well, I'm sorry, I'm a little nervous. This is not something that I've done in the past, nor something that I ever looked forward to doing. She stated in there that she didn't find any cause for me writing a constructed resignation. I apologize. I wrote that constructed resignation because I was at a job that I really enjoyed, and I was a director there. My turn to was my town manager. And when I turned to him and let him know that somebody was definitely sexually harassing me at work, be it sexual innuendo when I was eating, he not just called me in the middle of the night with a butt dial. This was a video call from Facebook Messenger. This is not something where you just touch a random button and it makes a call. And the end result of this was this fella exposing himself to me in my office. I walked into my office and he was completely exposed with his penis in one hand and a milk jug in another. And again, this was brought to my town manager's attention. Nothing was done. And I just feel that the town of Machias failed to protect me as an employee. I felt a need to write a constructed resignation. And I see the investigator's findings here. And she states in this, and I want to refer to some of these. She states in here that the employee's inappropriate banana comment was an isolated incident. This couldn't be more false. The employee was hired for a split position, if you will. He was supposed to be 3 days in the Public Works Department, 2 days with the transfer station. It was within his first week of employment at the Public Works Department, they found him following young ladies into the convenience store, asking for their phone number. They found his behavior to be inappropriate, so they moved him to the transfer station full time. So I essentially had to deal with Sean one-on-one. And there wasn't a week that passed that I didn't report him to Bill Kitchen and ask that something be done. And Bill always said, the town manager always said that he would follow up with the chat. And nothing was done. It states in here too that Michael Shoppy, the director of the Public Works Department, was supposed to speak with the employee. This
Ms.
here
Greiser?
couldn't be more untrue.
I'm just gonna
The
ask you
director of the
to, Ms.
Public Works
Greiser,
Department,
Ms. Greiser,
he was not
Ms.
he was not
Greiser.
there. He was out on medical leave from mid-November until probably the first week in January. So
Ms.
during this
Greiser,
whole
I need to
period,
pause you for a moment. Can you hear me okay?
yeah, I'm
I just,
sorry.
yep, I need you to, when I say your name, I need you to pause. I have paused your time, so you won't lose time. It's very important that you not use the names of any
Okay, and I
person
do
who is not
apologize.
named in the complaint, okay?
Okay.
All right.
Okay, well, again, I just wanted to bring it to your attention that the director of Public Works Department was not there at work from mid-November, maybe mid to late November, until sometime near the first week or the second week in January. So the idea that in this report, it states that the town manager had asked the director to handle this issue with the employee, that's a falsehood. There's no truth to that. Again, that director was not, he wasn't there at that time. The acting director who was there was never called to question in any of this. And it was at his direction that this employee be taken away from the public because of his lewd behavior and be put into the transfer station full time. So, I mean, my point is this is a problem that was occurring. The town manager was aware of it. Everyone there was aware of it. There was no secret. And this is a job that I liked. This is a job that my town manager stated he valued me. He said I was a valuable employee. Why wasn't I valuable enough to take seriously and say, hey, there's a problem. There's a man who has now exposed himself to a woman in her workplace. I actually felt unsafe to work there. I just, I'm asking that all this be considered because I have facts. There were witnesses that were never called to question. There was a witness who had not only sent a letter to Maine Human Rights Commission, but also I have a confirmation on faxes that he sent. That was never considered. I'm wondering why these people weren't considered in this action. I'm wondering why I wasn't taken seriously as a woman to be left in a workplace where someone exposes themselves.
That's actually your 7 minutes if you want to pause there.
Yes, I will.
Commissioner, questions for Ms. Greiser? Commissioner Douglas.
Yes, good afternoon. So I just want to make sure that we all have the same facts, right? So in the investigator's report, there are 3 incidents. There's the urinating in the scale house incident where you say he exposed himself to you, right? There's the butt dial, which I understand is a Facebook. You're saying it's like a Facebook Messenger when like you call somebody from the
Yes, exactly. He actually video called me from it, and that's a little more than a butt dial.
Okay, so right, so the implication is that he was looking at your Facebook profile and then either called you intentionally or negligently, right?
Mm-hmm.
And then there's the banana comment, right? So my question for you is, because you sort of obliquely referenced several incidents. I need to state this very carefully. Are there any other inappropriate incidents that happened between you and this person that you've already told the Maine Human Rights Commission about?
Yes, there is.
But the key part is, did you tell the investigator about those incidents, the other incidents?
Yes, sir, I did.
Okay. All right. Thank you.
Any other commissioner questions for Ms. Greiser? Commissioner David.
Yeah, Ms. Greiser, what are those other incidents?
The other incidents.
Oh, sorry. Did I miss your hand?
Okay.
Were you gonna ask that, Tom?
Sorry. No, you go ahead, man. I'm sorry.
The other incidents that I brought up to my town manager, as well as was in my first statement, his behavior was, it was always vulgar. I actually had to report the employee as well, because there was almost an altercation between him and another employee, which was a man, due to this employee's lewd behavior.
And the suggestion is, it says in the report that you were told by, I'm not sure whether it was manager or exactly what, that you should write up the complaint so that it's documented. I think about the banana, and you declined to do that, right?
Well, no, I didn't decline to do that. It was never suggested to me to write him up at all.
It was not suggested, and so
Absolutely not.
you differ with the investigator's statement to that effect?
Absolutely, I do.
Okay. And the incident with the urinating in the jar, obviously crude, inappropriate to be doing that in that space, but you describe it as exposing himself to you. Could that not also be unintentional? You open the door and he's doing this, you know, he's urinating in the jar. He's not trying to do something sexual to confront you.
No, I don't feel it was unintentional. I feel it was very intentional. It was done in the scale house, which is my office. I was walking towards the scale house when he was exposed. There is a window in the door, and there's a window on every side of that building. It's a scale house. People drive up to it. So you can see around that whole building. There's no way he would have missed me coming into my office when he was exposed.
Thank you. Any other commissioner questions for Ms. Greiser? Seeing none, you'll have 3 minutes left when we come back to you. Attorney Costello, do you want to reserve any of your time?
Whatever's left. I don't, I put in my written submission. I don't have a great deal to add to that. And I appreciate the opportunity to present to you today, even though I'm last. Sometimes being last gives you a chance to do your best effort. So just a few things. This is again another constructive discharge case, and also a hostile work environment. And we know that the standard is pretty high. If you'd look at the initial complaint talks about the incident, the banana joke, and in the law, they look at the type of joke that it was. Is it directed towards sort of someone personally about their own physical appearance and that? It's not. It's really his joke, inappropriate as it may be, is sort of a self-deprecating, sort of inappropriate joke. So he does that. Then there's the mistaken call. Was it a mistake? From the employer's perspective, you ask and you say, well, they tell you, well, look, it's an error. So he was asked about it, which shows that the employer was doing something about it. Importantly, she didn't answer the call. So that's number two. When we look at severe and pervasive, called one time. And then, of course, the third one was the allegation that he was exposing himself. Well, he had a jug in one hand, and obviously that supported the fact that this was not that he was his story about what he was doing fit the circumstances. If you look at the initial complaint, there isn't allegations of all of this. Well, he was inappropriate all the time. We got that later in the case, but there was never any real specifics. And timing is very important in this case because, as you can see, he didn't even come into the service until November 23rd. This joke was, at least the initial event, was sometime in the first week of December. She left December 23rd. So we're talking about a time frame of less than 3 weeks. She states that Mr. Shoppy didn't get this information from the employer. Mr. Shoppy testified
Attorney
that.
Costa, he's not named in the complaint, so
Oh,
if you
I'm
could
sorry.
use his title.
Yes, I'm sorry. The manager, she said, was out. Whether the manager's out, he's still an employee. So she's assuming that the town manager and that manager didn't have a conversation because he was out. They can have a conversation. In fact, it's in the record that he came in actually when she was there in November. So her assumption that this is proof positive that the two of them didn't communicate, it is just that. It's just an assumption. Importantly, too, are the things that she said at the end. She said, I didn't know how long it was going to last. Because she left on December 23rd, and while she was out, she said, I'm not coming back. She was offered to come back, didn't say, hey, if I come back, I can't work with him. There wasn't any request like that. In her own statement, she said, I was told by the town manager that this would be nipped in the bud. And again, the time frame is if the town manager learns about it, at least the facts from our perspective, he learns about it at the transfer station in the first week, late in the first week. He talks to the manager. He talks to her about it. This is not somebody who's, not taking her complaint seriously. It's not even alleged in there. In her termination letter, she says, I have zero tolerance. And what it really was is just she felt that this should have resulted in an immediate termination. And those know that generally these kinds of things where there's inappropriate sort of sexual innuendos and those kind of things, they're more in lines of, progressive discipline is really more appropriate. She never really reached to the standard that was required. And that was the operative portion of the investigator's report, that yes, she was exposed to this joke that she shouldn't have been, was always determined by the town that it was inappropriate. But when the town says, hey, we want you to come back, this guy was a probationary employee. They didn't have to even have a reason to terminate him. When she said, I'm not coming back, and she was offered to come back, one would think you would at least inquire, well, what's going to happen with this other individual, which of course never happened. How in a 3-week time frame you can get to severe and pervasive on these facts seems more than problematic for the petitioner in this case. And, I have to state that the investigator's report is spot on in the law. It requires a lot, and a lot isn't here. That's my pitch. Thank you. Any questions for me?
Any questions for Attorney Costa? Yes, Commissioner O'Brien.
Thank you. I don't know what I'm missing here, because it was a short amount of time, you said, and it wasn't pervasive. And the fact you said repeatedly a joke, I don't think that's a joke at all, the banana comment. And you said, well, she did not pick up the phone, so the call wasn't completed. It, in my humble opinion, irrelevant. And the final one about the urination. You want to try to help me out? Help me out. I'm not there.
I'll help you out. The joke is it's a poor attempt at humor. It's not. I'm not condoning what he said by any stretch of the matter or trying to justify it in any way. But the Supreme Court in the case law looks at the type of comment that it was. It finds more traction, if you will, to those comments about someone's personal characteristics, and those are generally viewed as sort of more significant than someone's poor attempt at humor. When I say it was a joke, doesn't mean it was inappropriate. I think it was an attempt at humor, inappropriate in the workplace. So that's number one. And the other ones I'm looking at really in terms of what's the employer. This employer went and looked at the events, and so when they go to look at the events, if he says it was a mistake, you know, and it was a call, you know, and you have to show that you were subjected to something. So if you don't answer the call, I just wanted to state that the only thing she was subjected to was the telephone ringing, as opposed to if it had been answered, there had been more to it. So I'm not trying to justify anything, but I'm trying to put them in context of what they were. So that would have been the second one. And the third one, if they go in and he says, I was attempting to urinate and she walked in on me, you know, deciding which one is accurate, you know, the employer has to look at both of them. And I think they did. It's not that they didn't talk to him about being inappropriate. They did. And the time frame is critical in this case because, and again, we have 3 separate incidents. So I hope that answers your question, not to justify any of it, but to put it in perspective, if you will.
Yeah. Commissioner Douglas and then Commissioner David.
Yeah, so afternoon, Fred. You know, I'm just I'm thinking through these facts and I'm finding them a little bit more problematic than I first did when I read this report. I mean, first you have the banana comment, which I think we all agree is inappropriate, right? But then I thought this was like a call, right? The second thing where it's, you know, somebody, you know, you got your cell phone and it's in your back pocket or something, you accidentally call somebody. It's happened to everybody. But that's not what the complainant describes. She describes a Facebook message where you have to, he had to navigate to her page, right?
That's not in the record. I want you to know that is not in the record at all. That's something that was added. The call was in there, but this distinction about how it was done, it is not in the record.
Okay, well, I appreciate that. I appreciate that. And then this last bit about the scale house, and I'll get your take on this. The complainant says that's her office. What is it? What's the situation there? Because if he's like he's got his stuff out, and he's going to the bathroom in her office, that seems problematic.
The transfer station, that's where you operate it from. If he's running the transfer station, that's where he is. This is not a private office for somebody. This is like you can imagine a transfer station. There's a booth there, right? Where you, as people are coming in. And this is not a private office. This is where he was stationed to work. It's wintertime. And I guess he didn't want to go out in the cold, you know, which, you know, if he would have, you know, been there, you know, waiting in, you know, waiting, but, you know, he's got the jug in his hand. I'm not trying to justify it. It was a very unfortunate circumstance to occur, but at the same time, you know, if you walk in, you know, what are you going to do? It's wintertime. He didn't want to walk to the thing. You know, obviously this guy wasn't a model employee. They didn't keep him. You know, he left. He had some issues, but again, they were being addressed, and they never got an opportunity for in the sort of hostile work environment. You know, it didn't rise to that level because they were working on it. When they said come back, you know, they could have done anything with him to separate him, done anything, but they were never given that opportunity. And that was the crux of it. Okay. So that part's not in the record on one of your questions, and the other is this is a, you know, where one works when they are assigned to the transfer station.
All right, I think you and I are on the same page in terms of what your position is. So thanks.
Okay.
David.
Like Commissioner Douglas, I when I first read this, I now am guess, paying closer attention to these facts, and they're more troubling. You're saying that he makes a mistake at 4 o'clock in the morning to try to call her on Facebook?
You know, one, if you're typing on the keys of a computer, I don't do Facebook, so I don't know. But
Neither
if
do
you're
I.
typing, you're looking at it, whatever you're doing. I'm looking at it from the employer's perspective, where they say this was a mistake. And again, the thing about how it was called, the fact that it was on Facebook, is not in the record.
Does he apologize to her for the banana comment?
You know,
No.
I don't know what the apology was. I know that it was reported and he was taken aside by the town manager and told him that he was inappropriate. He was also taken aside by the manager and telling him, look, you know, this is inappropriate and you can't do this. That's what I know. Yeah, I don't know if he individually did it or not, you know, I don't. It's not in the record either, one way or the other.
He acknowledges, well, all right, never mind. Thank you.
Commissioner O'Brien?
Yeah, I just want to point out to the other commissioners and whoever else. It does say in the record, video call from Facebook Messenger. And then it also says that, talked about being cold, didn't want to go out in the cold. I understand that. But there was a restroom at the transfer station less than 30 feet away.
That's right, outside.
Correct.
Right. I've got it. You would, I wasn't saying there was no bathroom there, but at the same time, you know, it would have had to walk out in the cold to get there. That's my understanding.
Okay, thank you.
Rather than do it in her office.
Right.
Well, it's the transfer station.
Okay.
Any other questions for Attorney Costa? Okay. And then you'll have just a little under 4 minutes when we come back to you. Ms. Greiser, you have 3 minutes left if there is anything you'd like to add.
Yes, I would like to add, I want to point out that that was in fact my office. I did the bookkeeping in there. That was most certainly my office. There was my office. There was another room where we moved the trash compactors, and there was another room where we did recycling. So that was in fact my office that Sean was in. So and I wanted to point out, as she already pointed out there, that it was a Facebook Messenger call, and I stated it was a video message originally. And I want to state again that there was never any talking to. And if there was talking to, why was I not made aware? I was the director of the transfer station at the time. I looked for direction from my town manager. There was never a directive for me to write someone up. There was never a conversation between me and the director of public works regarding that employee until December 24th. So the idea that he even states in there, director asked complainant if she wrote up employee, complainant replied, well, I probably should. You know, I'm really not one that's faint of heart. I wouldn't even present myself that way to a person. So the idea that someone even make a statement like that is ridiculous. All I asked for in this was help. And I didn't feel like I should be left to work with a man who was 6'4", who exposed himself to me in my workplace. I do work with predominantly male field right now. Just to let you know, I'm a manager of over 30 men. Never have I had a man present himself to me in that manner. And I asked for something to be done here. And again, nothing was done. And that's all I asked was for Machias to protect me in this.
You say nothing was done. They say they counseled him or spoke to him. Did they report to you that they had talked to him about the inappropriateness of his?
No, sir, they did not. No, sir.
They did not
No.
come back and tell you, we've taken care of it, or we're dealing with it?
No, sir, they did not.
All right, thank you.
Any other commission questions for Ms. Greiser? Okay, seeing none, Attorney Koslow, you have 3 minutes and 53 seconds if there's anything else you'd like to add.
I quote directly from her last response. She states, Michael Shoppy came into my office on the transfer station at December 23rd to wish me a happy holiday. I asked Michael if he was aware what's going on. He said, Bill, meaning that, excuse me, I'm sorry.
Okay.
The manager made him aware, meaning the town manager made the other supervisor aware he would be nipping this in the bud as soon as he is released from employment again. So this thing, nobody did anything. In her own statement, she was told on November 23rd it would be nipped in the bud. That's her statement. And so to sit here today and say, well, nobody ever told me, it's directly contradictory to what she's just said. I could understand why she didn't know what the town manager and the manager may have discussed. She believed they were out, but that didn't mean they couldn't communicate, number one. And the manager said he did communicate. And so this was made aware. And if you look through the complaint, there are limitations, as you know, when an employee is being, how much you can relate to the investigation to the complaining party. So it's not unusual that every step that's being taken is not being related to another person. Many times, because of the confidentiality, what happens is the employer is investigating the alleged perpetrator, and that information is not shared directly for privacy reasons and others. That's not atypical in any kind of these cases. So the direct contradiction is right there. She was told it would be nipped in the bud, and she left anyway. And even when they invited her to come back, she didn't. And I say that even though the event that you're focusing on, this action has to be, severe and pervasive. And severe and pervasive, this particular event, as unfortunate as it was in the town office, we can't presuppose, which fact, would be accepted. And even if it was, the whole thing could have been avoided at the end by simply telling the employer, I don't want to work with him anymore. I'll come back under those conditions. And that never happened. And that's why the investigator felt that it was appropriate for a no reasonable grounds finding. Thank you.
Commissioner questions for Attorney Koslow? Commissioner Davis.
It seems to me in what you just said that, I understand the argument that you say those incidents don't meet the standard of being severe and pervasive. I understand that argument, and you're saying that's why we shouldn't say that it was discriminatory behavior. But do you concede that the incidents are the reason that she did leave? Is there any other motivation for her resigning?
On a hostile in work environment in a constructive discharge case, she said, she says, I have zero tolerance for it. So I'm taking her at her word that those are the reasons she left, but that doesn't change the legal standard of what's required. If what you sort of person, pardon?
Never mind, it's argumentative.
If it's not a subjective standard, it's an objective standard. And so I can't deal with it is not really the issue. And the Supreme Court, there's been actions far more severe than this that have been found to not be severe and pervasive. Jokes and other actions I mean, I'm not suggesting that one event can't be it, but those kinds of things are when somebody grabs an employee, does something so overt that there's no other explanation for it. We don't have that here. We have what we have, those three events. And when there's already an action in place that for corrective action, you can't leave and simply say, I'm not going to let that happen. She stated in the things, I don't know how long this would take to repair. And if she didn't know, whether it would take a day, a week, or a month, that's insufficient. You have to let the process work, and they were working on it. And I think it's pretty clear from her.
Thank you, sir. Thank you.
All right.
Any other commissioner questions for Attorney Casa? Seeing none. Thank you both. Next, we'll hear from Angela Morse, who investigated this case.
Hello, my name is Angela Morse. I was the investigator assigned to this case. So I just jotted down some notes that I wanted to go over. As far as how this call came about, the complaint references a video call, and during the issues and resolution conference, we discussed a phone call. I was reviewing all the submissions in this case, and it looks like the only reference to a Facebook Messenger call would be after the report was written. I'm not sure that.
Yeah,
are you using a microphone that is different than usual? We're having a little bit of an echo on your end.
She's using a speaker mic, which is.
No.
Okay.
Just my computer. Can you hear me okay? Or?
We can hear you. It's just a little, there's a little reverb.
Yeah, I have no idea why.
Okay.
Okay. So, when I was, writing my report, that was the information I was using, the reference to a phone call, a video call, and an explanation of the call being a butt dial. As far as, the incidents that occurred, there are 3 discrete incidents referenced in the complaint. We discussed 3 incidents in the conference, and, those were the banana incident, the urination incident, and the butt dial. As far as, what occurred here during the conference, there were 3 representatives for the respondent. After the conference, I thought in order to get all the information I needed, I wanted to follow up with the director. And I did do a separate conference with him to gather more information. The manager was interviewed for this case, but unfortunately he passed away during the time of my investigation, so I didn't get to interview him by myself, but he was interviewed in connection to this case, and his testimony was incorporated into the respondent's answer. Going to the standard of severe and pervasive for a hostile work environment. So severe. So actually, let's look at pervasive. So we have 3 incidents here. In my opinion, only one of those was sexual in nature, which is the banana comment. And to me, that one comment, although it was certainly not appropriate, and I think everybody's in agreement there, does not meet the standard of pervasive. Again, looking at that comment, I also don't find that comment to meet the standard of being severe. That's my interpretation of how the law fits in with the facts of this case after doing a pretty extensive investigation in this case and getting quite a few submissions from the parties. And as far as the constructive discharge claim, we're looking, in order to support that claim, we need to look at, was there no reasonable alternative but for the complainant to resign? And I simply don't believe that that was the case here. There was no, accommodations asked for, there was no dialogue about, how, the work, situation could be restructured so they didn't work together. There was a plan in place, and this is supported by, the director and the manager to discuss this after the holiday break. All these incidents occurred in a very small period of time, and in that period of time, we had, various holidays. We had Thanksgiving holidays, we had the holidays in December, and then the complainant was out for vacation and resigned before coming back to work following that vacation. So I simply don't think that there, we were at the place where there was no reasonable alternative but to resigning. And the complainant does mention a couple times in submissions that she has zero tolerance for this sort of behavior. And while I can certainly respect that, that's not the standard we're looking at. We're looking at an objective standard, not a subjective standard. And again, I just don't think, based on the specifics of this case, that we meet the criteria to determine that this is a hostile work environment or that this is a constructive discharge claim. And if you have any questions, I'll certainly answer them. Yeah.
Sanders.
Thank you, Angela. On page 4 of your report, with respect to the phone call, and then with respect to the urination incident, it looks like, at least with respect to the phone call, you indicated that you found the employee's explanations credible. And then also too, it appears that there's an inference there that employee's explanation for, why was he urinating in the transfer station, the explanation that he gave was credible, right? Not related to the complainant's sex. Tell me more though, upon what did you base that credibility determination? My impression, right, is, an attorney for the respondent noted it in his presentation, which is, this is not a great employee, right? Lots of inappropriate conduct. In fact, we know this particular employee is no longer working for the town, or at least was no longer working for the town very shortly after these circumstances arose. And so why did you make the credibility determination in the employee's favor?
Yeah. So as far as, to me, that makes perfect sense that that was an accidental call, whether it was, a phone call, a video call, done through a social media platform. I don't think that that call was intentional at 4 a.m. That just does not make any sense to me. We're not really discussing why this phone call occurred, but whether or not it was, intentional or not. And I definitely think that that is a credible statement that it was an accidental call. It just, again, 4 a.m. just does not make sense for that to be an intentional time to try to call the complainant. As far as the urination incident, I can see how that could happen. There is no restroom that's close by and easily accessed. So I can see how that could happen. I think that it's credible that that was in no way directed toward the complainant, that action. Certainly it was unfortunate that, the complainant witnessed that. But again, I don't think that was directed towards the complainant in any way. And then as far as the employee being discharged from employment shortly thereafter, I did ask about the reasons for that job termination, and they were completely unrelated to this. It sounded like he stopped showing up for work.
Okay. Can I ask though to, let's say, for example, we don't find the employee's explanation for the phone call and the urination incident. Let's just say we don't find those explanations credible. Would you then conclude that pattern of conduct, right? The 3 incidents that we then have before us, the wildly inappropriate comment, the urination, and the phone call, could those three events in such close proximity and time strung together meet the legal definition for severe, persistent, or pervasive?
Yeah, I think that's kind of hard to answer because, I really have to go by the specifics here. This was not a call at midnight or 1 a.m. This was a call at 4 a.m., probably right before the workday. We just don't have, it's not a different scenario here. That's what happened. To me, I don't think there was an intentional call at 4 a.m. That just makes no sense to me. As far as the urination incident, again, I don't think that was directed towards the complainant. And again, I just don't see how that could even be, really be orchestrated in a way that was that the employee was thinking that the complainant was going to witness that. So yeah, could it be severe and pervasive? I guess, but that's not what we have here. And I'm just basing my interpretation on what the specifics here, because if we change those specifics, then we have a completely different case. So I don't know if that answers the question or not, but.
Yeah, thank you.
David?
Angela, I think, well, we can differ about whether the 4 o'clock in the morning, but it's in the context of the next morning, 4 o'clock in the morning, after a blatant, direct sexual overture about his recent sexual experience in the context of her eating a banana and that allusion. Is it your understanding, and I should have asked this to the parties, I agree, I don't use Facebook either, but my understanding is that she was able to identify where that request for contact was coming from in declining to respond to it. Is that not also your understanding? In other words, we're saying it's a phone call. I don't think it's a phone call that she, doesn't answer. I think she sees on Facebook who's trying to contact her. Is that your understanding?
Yeah, so I was looking, while the parties were presenting, I was looking at the filings in this case, and I couldn't find any reference to Facebook until the submission of disagreement, which, and I should have caught the Facebook and redacted that little piece, but I don't see any message or anything relating to Facebook specifically until after the report was issued. I think this occurred on the phone. So I think maybe that's why, phone call was used, video call. I don't know what that means. And to me,
I don't think
it
there's
would
any
be.
difference now, though, Angela.
Huh?
I understand how it got written that way, but I don't think there's any difference now that it was not a phone call. And I conclude that it's totally improbable that it was a mistake, which is what we mean when we say.
Is it a question for the investigator?
No, it's an argument.
Okay. I don't argue with the investigator. I can argue
I want to
myself.
change your mind. Thank you, Angela.
I assure you that's more difficult than we've got time for.
Any other questions for the investigator? Okay, seeing none, thank you, Angela. Heard from the parties and the investigator. Commissioner David, do you have a motion?
I do. My motion is to find that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of sex, and conciliation should be attempted. And I'll speak to that if there's a second.
I'll second.
It just is, this is a sequence of a blatant sexual overture, and the next morning at 4 o'clock in the morning, and we don't know why he chooses that, but he's trying to make contact with her for no claim of any other legitimate reason than to continue to hit upon her. She adds detail that we didn't have before about making it a close call about the urination and whether he knows he might be exposing himself and that she might be coming in, or whether he sees her coming and decides to, wouldn't this be cute to say I'm urinating when I'm really trying to expose myself? And we know he's gone shortly thereafter. This business about she has zero tolerance, I think she's entitled to have zero tolerance in the face of that blatant kind of overture.
Further discussion.
I think the piece that, that I'm trying to drill in on is even if we decide, right, the complaint, the employee in response to the urination issue and the phone call, even if we decide that he's not credible, right, in what he reported to the investigator, even if we do string together those three incidents to create a pattern here, the question for me still as a legal matter is, did the employer have a sufficient opportunity, right, to investigate it in a thorough and comprehensive way, and then, land on an appropriate remedy to address, the complainant's very real concerns here. And so that's the piece for me that I'm struggling with, right? The time frame is so short. Investigators said, look, there's holidays in between. The employer communicated to the complainant, we're working on it, we're dealing with it. When you get back, we're going to sit down and talk about how do we make sure this doesn't happen again, right? What's the appropriate remedy here? For me, that's the piece that that's the piece that's concerning for me. And so I'm curious, if other commissioners have thoughts about that particular piece.
I hear you, Megan, and that's where it begins to be as likely as not, and something that I think might be decided that it's plausible in a lawsuit that she would prevail. That would be I hear your concern about that, but I think it's just as likely that she makes the report to the males who are minimizing it and slow rolling it, and we'll take care of it later.
Commissioner Douglas and then Commissioner O'Brien.
Yeah, Commissioner Sanders raised precisely the point that I was going to raise. I mean, first of all, I think that this absolutely is, the conduct is pervasive enough to rise to the appropriate level. I mean, I'm sorry, the way Facebook works is in order to do that call, you have to navigate to her page. So first he makes the sexual comment.
Keep in mind that Facebook was not in the record. That was not information that was available to the investigator when she wrote the report.
I understand, right? I appreciate that, but if she, and I mean, we're entertaining it here, right? So I haven't heard anybody say we shouldn't entertain it. So if she testifies to that at trial or some sort of video call anyway, right? I think that was in the complaint. Somebody said that. So he makes the sexual comment, then there's a video call at 4 a.m. A lot of people at 4 o'clock.
Not on the record that we didn't have. I know we're not.
Do you want Carrie? I don't know why Carrie's talking.
Okay. So anyway, he makes the sexual comment, then he's video calling her at 4 a.m. Lots of people up at 4 a.m. I don't credit the fact that it's 4 as automatically meaning it's an accident. And then he's urinating in the scale house, at least that's her allegation, while there's another bathroom 30 feet away in the transfer station. I find these things to be problematic. Where I think the issue really comes in, for me anyway, is, it seems like the employer was following up on it. They spoke to him. I think they could have done things a little faster, but I think their duty is to investigate, right? I mean, I think that's their legal duty. I think they were. So I don't know. That's the part of this that I'm wrestling with, like Commissioner Sanders here.
Commissioner O'Brien.
I probably tipped my hand, I said that, but to me, again, as the non-legal mind, to me, it is. I have heard all of my fellow commissioners use the term at least an equal chance. And to me, if nothing else, it is at least an equal chance. So that's where I am.
Any further discussion? Seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Yep. Okay, Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
No.
Commissioner Sanders.
No.
So the findings are reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing. Now we need a motion to go into executive session, and then you can all have your lunch.
Pursuant to 1 MRSA section 405-6E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
For a second. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
All right.
What could go
Go wrong.
Yeah, I have to go, guys. I was
All
supposed to
right.
be out here at like 12:20.
Thanks, Sam.
I thought this last case would take like, we'd be done by 12:30, 12:35. Of course, that's silly
no.
of me. You guys
Thank
have a
you.
great day. Yeah.
Bye. Thanks, Tom.
Meg, can you still?
I can. There's a little bit of an echo, but I can still hear you. Oh, are you supposed to be on mute, Kit?
Yeah, I'm just working out some logistics, Meg.
Okay, great. Thanks.
Lunch is here if you guys wanna grab some while I see if I can.
I'll get away. Sure. Yeah, thank you.
St. George MSU. Not to litigate E230254 Scott versus Albert.
So moved.
I have a second.
Second.
Thank you. All those in favor, Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Right, thanks, everybody. Have a lovely afternoon. Hopefully at the June meeting, I'll have an update.